Som. Good morning, ladies and gentlemen. Welcome to the second day of ICN's Annual Conference 2024, hosted by the Administrative Council of Economic Defense, CADE, here in Sauípe, Brazil. This morning we have two plenaries, followed by a 30 minutes coffee break, and the second round of breakout sessions. We will start with the first plenary session titled Unilateral Conduct Enforcement, Current Trends and Challenges Ahead. As moderator, Camila Alves, Commissioner of CADE Brazil, and the speakers, Benoit Curé, President of Autorité de la Concurrence, France, Melanie Attikin, Managing Principal, NGA of Competition Bureau, Canada, Rickard Gjerstem, Director General, Swedish Competition Authority, KKV, Sweden, Andreas Schwab, Member of the European Parliament, and Marisa Tierno Centella, Director General of the Comisión Nacional de los Mercados y la Competencia, Spain. Camila Alves, the floor is yours.
Thank you so much. Good morning, everyone. I apologize for my voice. I can't find a good reason why I lost it last night. I don't know, maybe I'm allergic to sea breeze or paradisiacal atmosphere. But today's session is at the Unilateral Conduct Working Group of the 2024 ICN plenary. We'll dive into unilateral conduct, discussing current trends and challenges ahead. Our discussions is set against the details in the accompanying slide, which outlines various aspects of unilateral conduct that is going to be on soon, considering under different legal frameworks. Today, we have a panel with distinguished speakers who will address key issues, such as the challenges in designing remedies for rapidly evolving markets, the impact of digital platforms on market dynamics, and the effectiveness of voluntary commitments and innovative remedies in resolving competitive concerns. Each speaker brings a wealth of experience and a unique perspective, of course. Please join me in welcoming our first speaker. I don't want to risk myself, so we will follow the alphabetic order today. So please, let's begin with Mr. Andreas Schwab.
Good morning, everybody. Thanks for giving me the floor, and a great thanks also to CAGE for this really terrific conference, and I think we all enjoy this. Now, you allow me that I make a rather political introduction into that topic of unilateral conduct enforcement. In the European Union, we call this abuse of market dominance, which gives you maybe an easier picture about what we are speaking. And you may have followed that over the years, I think since more than 10 years, we can say, we have been trying to push authorities in the European Union to take action. But it has taken until 3 years ago, that finally we got a new tool, which is called the Digital Markets Act, that I had the pleasure to care about in the European Parliament. And this law wants to face two key problems that authorities, from my understanding, have been fearing and have been suffering for in the last decennies. The one side is that existing competition policy procedures are too slow because you always need to prove the wrongdoing as an authority, and this with digital matters can be very complicated and time-consuming, and when you are ready to prove it, you discover that companies have already changed their algorithm or their programs. And secondly, you have to go to court to wait for a decision, and courts were not always used to the questions and the matters in question. And secondly, court procedures are quite slow. So our existing tool set is very, let's say, inadapted to digital markets, and therefore with the European law called Digital Markets Act, we wanted to shift this. We have changed the burden of proof, which is now with the big companies. The scope of this law is very limited. Only a few companies have to respect these rules that are coming from existing competition policy principles, and they have to prove that they abide by the law. So the change of burden of proof shall make it much easier for authorities to apply these rules, and therefore we are looking forward that the European Commission is applying them now. So far there is not yet a decision. But what is the key question here? The key question for lawmakers is, what is more important, competition or innovation? And the general question will be, can we combine both? Because there can be no doubt that digital markets have been driving our societies to a very new high level of innovation, but at the same time, gatekeepers, the biggest companies, have reduced competition too much. And our task has therefore to be, at the same time, to allow innovation and to care about competition. And that's not easy. We have heard yesterday from the Australian colleague in the national competition authorities that 1% of companies last year made 95 of transactions, and there you see what economic power there is and how careful competition authorities have to do it. I think we can be, and then with this I would already come to an end, I think we can be still optimistic that the task ahead can be managed, because at least in the European Union we have an excellent cooperation between the 27 national competition authorities that are also sitting here with me and the European Commission, which doesn't mean that there are not some legal issues to be fixed, some problems to go over, but there is a very constructive mood to achieve this. And therefore, I'm rather optimistic that after having dealt with Microsoft 20 years ago, which had an impact to make grow Google and Apple and others, that if our action again can be as decisive as 20 years ago, in 20 years we will have other companies and more wealth thanks to digital markets. And I think this should be a bit the story. If competition is enforced, competition law, we will make markets grow even better. Thank you very much.
Thank you so much. We are delighted to have a different perspective from outside the agencies, and we are going next to Mr. Benoit Corret, President of France Autorité de la Concurrence.
Thank you, Camilla, and good morning, everyone. And let me first start by thanking very warmly CAGE commissioners and staff for the wonderful welcome and for the excellent organization here in Sauipe. I think it's good that we have the opportunity to spend some time on unilateral conduct, and I also want to thank the members of the working group, of the ICN working group on unilateral conduct, because it's fair to say that the effectiveness of unilateral conduct enforcement has raised questions in the competition community, and we've seen two trends. We've seen one trend has been to an apparent decline in the use of traditional competition instruments in the field of unilateral conduct, with particularly in Europe, with some nervousness or doubts on the use of some instruments, such as the use of economic tests in assessing exclusionary conduct under unilateral cases. Very lively discussion on the as efficient competitor test and so on. And at the same time, we've seen a rise in a rising interest for ex-ante regulation, as exemplified by what Mr. Schwab just said. And by the achievement which the DMA is in Europe, and thank you very much, Andreas, for making it happen. And so, facing these trends, there is a kind of existential question over the relevance of antitrust instruments when dealing with unilateral conduct. So I want to dissent. I want to express a dissenting voice here and share a little bit of the French experience, which has been actually very satisfied. We've been very satisfied with the way we could use abuse of dominance, well, namely Article 102 of the treaty. We've been, I said elsewhere that we've been happy users of Article 102. If you go back to 2022, for instance, nearly half of our decisions were based on 102. So we've been intensive users of 102. And maybe another difference is that while the discussion, the conceptual discussion and the legal discussion has focused very much on exclusionary abuse, we've been, in our practical cases, we've been focusing very much on exploitative abuse instead of exclusionary abuse, and in our view, in an efficient way. How can we keep these instruments alive? I would say we need three components. We need first to make full use of the competition toolbox. We also need to articulate the unilateral conduct instruments with ex-ante regulation. So we need a good complementarity between antitrust and particularly the DMA, but also the Data Act will come, and maybe the AI Act will have some relevance at some point, and so on. But so far we focus very much on the DMA. And third, we need good cooperation and intense cooperation with other authorities at a national level, particularly with sectoral authorities. So first on the use of the instruments, I would say that there are two objectives here. First, we need to be fast. And that kind of answers the concern that has been raised by Andreas on, antitrust being too slow, which of course is everywhere around us. And then we need to design the appropriate remedies. We need good remedies. So when it comes to being fast, what we've done in France has been to use as much as possible interim measures to shorten the process. In our two recent decisions based on interim measures, in 2022 on the Google related right case, we had been able to decide within 7 months. So that's in 2020 when we took the interim measures, and then the commitments came in 2022. I'm going to go back to that in a second. But the interim measures could be decided within 7 months. And last year, when we took interim measures against Meta in the advertisement verification industry, we could take the interim measures within 5 months. So that's pretty or starkly different from the kind of timeline we're used to under usual antitrust. And I do believe that interim measures are largely underutilized, and I would favor any way to help the Commission to use interim measures in a more proactive way, and certainly the ongoing review of Article 102 can be the right place to have that discussion. We also need to have the right remedies. So in France, we've accepted lots of commitments. We know that there is a downside to commitments. We know there is a downside to behavioral remedies, but in fast-moving markets, we also believe that one of our duties is to restore the functioning of the market, and commitments are one efficient way to restore the functioning of the market, also for the benefit of competitors and for the benefit of clients. So you can have the high moral ground and put a heavy fine on the company and then walk away and move to the next case, and you'll be very happy as a law enforcer, but you haven't helped the market very much. While if you take time to discuss and eventually accept the right commitments, you may make a difference for the functioning of the market right now, helping the competitors and helping the clients and the suppliers. So that's the approach we followed in several cases. We've done it in the Google News Corp case. We've done it in the Meta Criteo case. in 2022, which was about the which was about non-search advertisement by Meta, and we've done it also in the related right case, where we accepted commitments by Google back in 2022. Now, coordination with ex-ante regulation, I think Andreas has spoken to it quite a bit, so I'm not going to come back on and explain what the DMA is. But what's pretty clear is that we'll have to spend a lot of our energy together with the Commission, or under the leadership of the Commission, actually, over the next month and years to discuss the right articulation between the DMA and Article 102 enforcement. The Commission will have to focus quite a bit on the existing gatekeepers and existing core platform services, which gives plenty of space for national authorities and for the Commission itself to use Article 102 for any conduct which is not a conduct by a designated gatekeeper, or which is not related to a core platform service. Will keep using 102 in a very active way. So that will keep us busy. It's not only, by the way, it's not only about Article 102, it could be also about Article 101, which is not the focus of this morning, but I've been listening to the discussion all around in various sessions since yesterday on, artificial intelligence and how do we deal with partnerships in the AI space, and partnerships which in some cases, maybe most cases, will not be, cannot be handled through traditional merger reviews, for instance, because there is no control. Well, we can use Article 101 also to address that kind of cooperation if we believe that it impedes competition. So I think there is a bright future for both Article 102 and Article 101 in the digital enforcement in Europe. And finally, all of this also requires to discuss very closely with other authorities at a national level and at a European level. So we had, for instance, intense discussions with our data privacy authority, la CNIL, and we've even signed an MOU in December with the CNIL on deepening the cooperation and the dialogue between the data privacy authority and the competition authority. We have a few cases. For instance, the Apple App Store case, the so-called app tracking transparency case, which has not yet come to my board, so I'm not taking any view on substance. But since at the heart of it, this is a discussion on how Apple is seeking consent by users on the App Store and whether or not this raises competitive concerns. That's a discussion where, of course, the privacy authority is an important player, and we discussed it intensively with them. And in a sense, we are also delivering on the instruction of the European Court of Justice in the Meta Cartelant case. And it came easily because that's something we wanted to do anyway. So to conclude, we have a full pipeline of Article 102 cases. So most of them I can't comment, obviously. I mentioned the Apple App Store case, which is public, which will come to the board within the next month. We also have an ongoing investigation in the GPU industry, where we did a dawn raid last year. And there is a lot more which I can't comment. And maybe finally, the European Court of Justice decision on using 102 in a merger context, the TowerCast decision, also provides from a new, opens a whole new universe of possible interesting cases using 102 in the context of merger control. So. To conclude, the news of the death of Article 102 has been largely exaggerated.
Thank you so much. So please join me in welcoming Marisa Turner, Director General of Spain Comisión Nacional de los Mercados y la Competencia.
Thank you very much. Thank you for having me here. It's a pleasure as always, and we feel like we are amongst friends because we meet so often in this community. So I'm going to concur a lot with Benoit, I'm afraid. So one of the, yeah, because it's more entertaining if we disagree, but I will just say one word on the DMA, which is, okay, we meaning the investigative body, which I head in the CNMC, are going to be investigating also DMA infringements to help the Commission, who is the only one who will make the decisions in this field. But as Benoit has said, the DMA is concerned with gatekeepers using certain platforms and with certain conduct. And even so, competition is law is theoretically also applicable. We are very quick. We have 24 months to take a decision from initiation of proceedings until the body that is a decision maker takes a decision, with some possibilities for suspension, but 24 months is really, very short period. So let's say that we are quick in our decision making for all infringement proceedings. And then I will come to our practice on 102 and our equivalent, Article 2 in unilateral conduct. So over the last 2.5 years, we have really intensified our action in unilateral conduct. So to give you a flavor, we have had 8 finding decisions, not to speak about the ongoing investigations, that I will mention the ones that are known and not the ones that are not known. We also had some commitment decisions and interim measures in this field. And this, if you compare with the 5 decisions in the previous 6 years, you will see that we have really focused on unilateral conduct. Most of it is abuse of dominance cases, the large majority, but we also have the possibility to focus on unilateral conduct that would constitute unfair acts distorting competition, where you don't need to be dominant. And we are starting to use this article. We have proposed already to our council the possibility of using this, for instance, in cases of economic dependence and others. So we will see how this unfolds, but we have made the proposals. Our focus has been mainly in pharma, transport, postal, energy, and digital in unilateral conduct. And as I say, publicly known is that we have 5 ongoing investigations now, apart from the decisions that were made. So in energy, for instance, we have some cases, to give you a flavor, of self-preferencing in generation market, in electricity. And we have just had another similar case regarding renewable energy, also of self-preferencing. We are investigating Naturgy, which is, as you know, a big company, an electric distributor there, about alleged exclusionary and discriminatory behavior in metering services. We are investigating Repsol, whether it is taking advantage or not of its dominant position in the wholesale distribution of hydrocarbons in Spain, to the detriment of independent service stations. In the field of digital, we have a case that is quite advanced. I say it because the company made it public. So it's booking.com, which is being investigated both for exclusionary conduct, for exploitative conduct, and for these unfair acts of competition that I was mentioning before, in the provision of intermediation services to hotels, to online travel agencies in Spain. We have also another case, Google Alphabet, about possible restrictive practices regarding press publishers and news agencies in Spain. And in all these cases, we have this double base proposed. Then in pharma, we had very recent cases that we are now defending in court. One of them is Merck Sharp Dome, where we did a case for sham litigation, which is not something that you do so often. we saw that Merck Sharp Dome was trying to delay or prevent the emergence of an alternative patent for a product. We had Lydiant, which is a common case with other authorities in Europe, but we did not only the excessive prices but also exclusionary abuse. And there is interesting the remedies that we imposed, because in order to solve the problem of exclusionary abuse, we ordered to eliminate the clause of exclusivity that was in a contract, to give you an idea of remedy. And the other remedy was to order the company to market the product in Spain at the price that they had negotiated with the Ministry of Health. This is now in court. We will see what happens. We have had also in the field of international intellectual property rights with our incumbent association for authorship for copyright there. We have had a case, and this is interesting, in railway, where we have done rates for the first time by the unit that we have to monitor compliance with our own decisions. So this was a decision under Article 102 of 2017, and we investigated to see whether they had actually, gone along with the commitments or not, because we have suspicions they haven't. So we take action after that. And then finally, just to name another sector in the post, we had a case recently against the incumbent for loyalty discounts that brought us to this discussion that Bernard was saying about what is the correct standard about things. So to finish, I have made it a priority of the investigative arm of the CNMC to get into all these cases as well, even with interim measures as we had, with commitments in the case of Ecoembes that is in waste management. That's another decision that we got. And in order to tackle these practices, we have fines for companies, but we also have fines for individuals. Since 2018, we have fined 62 directors, and we have proposals for more for the council. And we have also the public contracting ban, I would say that this is a difficulty in unilateral conduct when you are dealing with dominant companies, because it is not obvious to say to the administration you cannot make a contract with a dominant company when there is not so much choice. So there we have an interesting issue of what we propose to the council and what the council can do about it, but we have this possibility. So I think I will stop there, because otherwise we will not get to any question. Thank you.
Perfect. Thank you so much. So next we welcome Ms. Melanie Aitica, co-chair of Bennett Jones LLP's competition sector and former Commissioner of Canada Competition Bureau.
Good morning, everyone, and thank you very much for including me on this panel. I need to turn it on. Pardon me. It's on now. So again, good morning, and thank you for including me on this panel, and for Kaje for the wonderful, warm reception. I'm particularly grateful as a demoted to NGA some years ago, participant up on this panel, of the openness to hear from the perspectives of, in my case, those who played on both sides, as it were. As we talk about these really interesting issues, I just wanted to offer up just three opening comments from a Canadian perspective, and from my perspective as a former enforcement official who very committed to the value of competition enforcement and very keen to see it effective and to help Canadians in our case. So first, many of you may know, Canada is in the process of radically reforming its Competition Act. Probably the most relevant for the purposes of this discussion is the change to the abuse of dominance provision. For 40 years at least, we've had a provision that required three things to be proved. Not surprisingly, dominance, market power in some form or another, a practice of anti-competitive acts, so some kind of anti-competitive intent, which can be inferred, and then, of course, a substantial lessening of competition, anti-competitive effects that can be demonstrated in the market. As of now, recently, it is no longer, unless the Bureau wants to secure an administrative monetary penalty, so think of a fine in a non-criminal context, they need only prove two of those things. So dominance always, but then only either the anti-competitive intent or the anti-competitive effects. In theory, this, at least, this definitely reduces the burden on the commissioner, and I'm not necessarily against that. I don't speak for the defense bar. I just want effective competition laws in Canada, and I'm encouraged to hear how much of that is going on around the world right now. But I think, what the tribunal will do with that, I suppose, is another matter. But in all seriousness, and I think I would presume to anticipate that the Bureau will probably still continue to bring cases that they at least are convinced have all three elements. Whether or not there may be some challenges in proving effects or intent, my expectation is that they will probably devote their scarce resources to those cases where they're most committed philosophically to there being a problem and an effect in the Canadian marketplace. I think it'll be difficult for those cases where perhaps there was just a dominance and an anti-competitive effect, because in those cases, there is a defense that the effects are the product of superior competitive performance, and I think it'll be very difficult to tease out whether it's anti-competitive intent or whether it's superior competitive performance. Where I think we probably will see potentially more activity, I think we already have a real example for, and that's where you have good evidence of dominance, of course, but you also have evidence of anti-competitive intent, but for whatever reason, it's difficult to quantify or put your arms around a way to explain the anti-competitive effects in a sort of an economic fashion. As I said, we have history with this. There was a case in Canada some years ago that was against our Real Estate Association. For the Americans in the room, that will be familiar. It was actually, I was inspired by your cases against NAR. But in that case in particular, there was, I'll talk about it for a moment in remedies, but for the purposes of this opening comment, it really was a case where there was very strong evidence of dominance. I mean, no question, they had an ownership of a very powerful platform that nobody else had access to but their members, and very strong evidence of anti-competitive intent. But for a bunch of reasons, mostly because competition hadn't had any chance to take root, which is often the case in digital markets, it was very difficult to show effects. And it didn't, for various reasons, lend itself to the kind of econometric modeling that we are used to often seeing in these cases. And in that case, the tribunal found that they had enough. Notwithstanding there really wasn't evidence of effects, which honestly terrified me when we brought the case, we were successful because of the power of the anti-competitive intent evidence to persuade the tribunal to find for the Bureau. My second comment is we've now actually seen our first case in Canada that I'm aware of that's public, so there may be others, but where the Bureau is investigating into concerns about the interoperability of software. The case I'm familiar with, I'm involved in, so obviously limit my comments to those which I think we could extrapolate some of the nuances to the challenges ahead. But basically the Bureau they're just at the investigative stage, but they've indicated that they are concerned about the extent to which the target has denied other software providers requests to interoperate with their market-leading foundational software. And I think, what I think we can take note of here, and I think it's important because it's very much under discussion, and I really think we need to challenge some of the underlying assumptions that we've long held, but also be careful to stick to principle. But I think, the question, of course, is the extent to which digital market participants are leveraging and denying their competitors access to valuable platforms, if you will, intellectual property that they've invested in, that they've taken risks to develop, and perhaps have satisfied or created and then satisfied a consumer demand for. Whether that is anti-competitive or whether that is the natural, predictable, and desirable consequence of innovation. Classic IP law would suggest that, in the absence of an essential facility, at least in Anglo-American sort of tradition, unless you have an essential facility, there's no issue here. You're allowed to, or you're abusing within the ownership of your intellectual property. There's no issue that you're allowed to enjoy the monopoly profits that come from the investment. I mean, I give a bad example, and it's probably not apt, but I think back to our COVID days. If we hadn't had Moderna and Pfizer with the incentive that they would ultimately be able to make some money off of this, I'm not suggesting they didn't also have a positive intent just to help the world, but for sure, it was that opportunity to someday enjoy the monopoly profits that inspired them to work as quickly as they did to let us all at least advance to the next stage in getting past that episode. So I think just where is the line between the interoperability, which sounds, good and sounds like a really fair and nice thing, and forced sharing of intellectual property, which if emphasized in this balance, I think we all risk losing something for. I am no apologist for corporate conduct. I think we've had far too many monopolists hide behind the shield of protecting incentives to innovate, so I'm not here in any way to proselytize about that. I think we've all become skeptical, and rightly so. But I do think we need to be mindful of drawing the balance. And we're going to have a bit of a pendulum, and that's okay. But just striving towards finding some balance ultimately in the enforcement such that we protect the benefits of innovation. My last comment is just probably really more as the function of age and perhaps knowledge forged in the crucible of winning some cases and losing some cases. But that's just the importance of enforcement. These are incredibly difficult issues, I think particularly in the unilateral conduct space, really challenging issues in the digital world with the pace of innovation, et cetera. And it's really important that we gather, as you all here are today, to talk about these issues that bristle with difficulty. And I applaud you all for doing that. I guess my caution, and this is probably because I'm by far so not the smartest person in the room, I think it's really important that we don't lose sight of enforcement. My 2 cents are that there is a temptation to talk. I'm so encouraged to hear up here about things people are doing, and we really need to do. Obviously, I believe doing so in a measured way, in a thoughtful way, and I know I share everyone's preoccupation up here as well with that. But the concern is if you don't, there is a risk that you'll miss opportunities, really good opportunities, while mired in talking and mired in studying. You'll miss good opportunities to do good things for the constituents that you're there to serve. Your people won't get trained, and you'll lose credibility if you don't actually do something, right? Getting mired in a big, long case is not necessarily the answer. Finding quick fixes, finding practical ways to make a difference, those are just as good enforcement. So I include all of that in enforcement. I just am concerned about, getting too mired in talking about in advocacy, all really important things, but all things that have their place with enforcement, I think, in my humble view, really being essential if we're going to make a difference. There's a concern you can become a parking lot for political issues, right? So in Canada, we've had, extensive market study power made much bigger with compulsory production powers, et cetera. I'm not against that per se, but it is a zero-sum game. There are only so many resources, and I get concerned that political issues get parked at the foot, and this is by no means the Commissioner or the Competition Bureau's fault. Issues will get parked at their doorstep for short-term political cover, right? High prices, high gas prices, inflation, whatever it be. And I don't think that's our highest best use. I think our highest best use, I say our, and I shouldn't, as enforcement authorities is to make a difference, to bring cases. I think at the end of the day, I think those tools, such as Benoit, for example, was talking about, are things we should all be thinking about. And as someone representing clients, I think we should absolutely be engaged in that conversation with you. And I just look forward to a really interesting chapter ahead, which obviously you are all in a really great position to take us. Thank you.
Thank you so much. So lastly, let's introduce Richard Johnston, Director General of Concurrent Vaccine.
Thank you. And I will start with echoing my fellow panelists and thanking Kaja for organizing this excellent event. Well, as many of you know, right now the European Commission is working on new guidelines on exclusionary abuses. And even though this is a Commission initiative, we are supporting them from a national forces perspective in the European Competition Network, which Andreas told us about. And the discussions about Article 102, they bring up fundamental questions that the ICN has been discussing for as long as there has been a unilateral conduct working group. I mean, the basic question, how to balance an effects-based approach with the need for workable, effective enforcement, how to ensure legal certainty as well as accuracy, and how to balance the risks of over and under enforcement. And it is important that we find the right balance here, because proper enforcement of abuse of dominance rules is vital to well-functioning markets. And we've heard about the DMA, Andreas told us about it, and this will be a major legal instrument in the European Union in the future. And we, as national enforcers, will be able to support the Commission who's making the decisions. So this is vital. But at the same time, it's worth keeping in mind that for agencies of our size, our abuse cases might not always involve digital large gatekeepers. We completely support the view that we need an effects-based approach to unilateral conduct, but at the same time, if competition authorities face unreasonably high demands on their effect analysis, there is a clear risk of under-enforcement. Too high demands will also discourage private enforcement, which is very important in this aspect as well. And if applying Article 102 becomes too burdensome, there's also a risk of ending up with a patchwork of national rules and fragmentation of the EU-wide approach to abuse of dominance. We ourselves, we have faced challenges in convincing our appeal courts to the desired extent in the abuse cases that have been tried on the merits in recent years. And private parties in Sweden have had similar difficulties in having their actions upheld in the appeal court. And there are several factors at play, and we shouldn't expect to win 100% of cases in courts. That's not the way. Indeed, we do prioritize cases sometimes that concern underdeveloped areas of competition law jurisprudence, and that's our task as an enforcer. But at the same time, it is reasonable to expect that our court proceedings are efficient and successful to a large extent. We have evaluated how we can develop our work to take account of the legal framework established in the Swedish courts to uphold the abuse of dominance proceedings. With that said, unilateral conduct cases, they are complex and time-consuming. So any efforts to create clear guidelines about the enforcement of the rules that can help both companies, authorities, and national courts is a very welcome step. In terms of recent trends, we have begun taking a closer look at exploitative abuses. We've decided that there might be grounds to take a closer look at, for example, excessive pricing in some cases, particularly in markets with large price increases that are also driving inflation. And this is it is a bit of a shift in relation to how we prioritized a few years ago. And the shift is, I'd say that it's prompted not least by the current situation of rising cost for many households. We have to be relevant. We have to be relevant to all who are depending on our work. We've recently investigated alleged excessive pricing in the market for district heating. We found that the particular company's prices and profit margins, they weren't significantly higher than comparable district heating networks. But many of these networks, they can be seen as are in fact natural monopolies. And the companies have significant market power. And we also seen that the companies face weak competition. We can't rule out that the district heating market in general might have unfair prices. And we have written to the government to suggest looking into the question of regulation. We come to that conclusion based on the fact that it's not normally possible to achieve functioning competition on a natural monopoly market solely by competition enforcement by itself. And we came to that conclusion driving particular cases. I can also mention that we've seen a series of abuse investigations that in different ways involve regulated markets, often including former monopolists, incumbents. And that has reinforced for us the importance of effective dialogue and cooperation with national regulators, which is very important. And as we have seen in other jurisdictions, the purpose of and compliance with other regulation may be informative of whether a specific conduct is anti-competitive or not. The cases also point to situations where there might be alternative ways to address a competition problem, where an individual enforcement intervention might not be the best way forward. In one case, for example, we investigated whether the state-owned incumbent train company's refusal to sell other train operators tickets through its own online sales channels, if that could amount to an abuse of dominance position. But we found out that any potential remedy to force the incumbent to sell the competitors' tickets wouldn't solve the underlying problem, which was about entry and expansion on the market for passenger transport. It might just cement the strong position of the incumbent's existing sales channels. So we concluded that the competition issue could be resolved more effectively by other means, for example, by more effective regulation of how passenger trains tickets are sold, which we then raised with the government. Just as a final point at this stage, our experience, much like we've heard from Benoit and Marisa, is the experience from digital markets have shown that it's important not just to be fighting yesterday's battles, as we've told about. And their interim measures are an important tool for fast-moving markets that are prone to tipping. And we have used them in a number of cases over the past few years. So we have much the same experience as Benoit and Marisa have told us. It's important to use interim measures. And I do hope the Commission will have better ways before us to use them as well. In one of these cases, we received a complaint about a plan announced by Nasdaq to admit to trading on its own SME growth market shares that were listed on a competitor operator's SME growth market without asking for the issuer's explicit consent. And our investigations showed that it wasn't established business practice in Europe for shares listed on SME growth markets to be admitted to trade at a second marketplace in the same geographical market. We found that the conduct was not in line with the purpose of the sector regulation and could have potentially severe exclusionary effects. We took an interim decision to temporarily ban Nasdaq from going through with its plan. And as a result of our decision, Nasdaq aborted its listing plans pending a review of the sector regulation at the EU level. And when we talk about fast action, I can say that from complaint to interim decision, it took us less than 3 weeks of investigation, which I'd say is exceptionally quick in our experience. Thank you.
Thank you. So before we proceed with the questions, we are displaying a slide summarizing some aspects of unilateral conduct in each jurisdiction and to provide a best comprehensive discussion. So I'm going following the questions, Mr. Andres. The Digital Markets Act introduces new tools and regulations aimed at managing one-sided conduct in digital market. So in your view, What are the most significant impacts of DMA on the tools available for enforcing regulations against unilateral conduct? And how do you anticipate the enforcement of unilateral conducts will evolve with the introduction of the DMA?
I do believe that, as has already been mentioned, the ex-ante rules that we have will make it very easy for the companies themselves to understand what is not allowed. They will for sure always look for the edges where the law is, as always in the life, not perfect, but it gives a very clear picture of how competition with these ex-ante rules should be ensured in global digital markets. And if I speak about global digital markets, it's interesting, I think, also to experience here how the different national competition authorities have to come together to share their experience, to assess what they can do differently or together, whilst these companies, they can decide all over the world out of one hand in 1 minute, which is for sure a very different level of power and of enforcement risks. But we have to make it a possibility, and I think we can very positively see already now that the idea of these ex-ante rules, especially for digital markets, is something that is expanding far away from Europe. We see it in South Korea, we see it in Japan, we see it in Brazil, also here with you. We see it in other legislations, and therefore I think the key will be that we are making aware, all of us, about the need not to wait too long with ex post procedures, but to try to be with an ex-ante tool set available. But even with ex-ante rules, as has been mentioned by our Canadian colleague, we have to act now. We cannot postpone, and I think that's a bit the challenge, because people say that if you touch the core business of these companies, they will go to court as long and as much they want, and that is for sure a risk. That's the reason why I mentioned already in my introduction that court procedures will also be decisive about this action. So we have also to make courts aware about the need to make competition a reality in global digital markets if we want to secure innovation. And we can for sure care a lot about innovation in AI if we keep this a new development, that we don't give too much into the hands of the old operators, of the existing gatekeepers.
Thank you. And Benoit Correux, voluntary commitments by companies can be important in resolving competitive concerns before formal enforcement is needed. How effective have voluntary commitments been in resolving competitive concerns before reaching enforcement stages, in your opinion?
Yeah, thank you for asking the question. It's a very important question, and to be fair, as a board, anytime we have to discuss possible commitments, we've got to ask ourselves this question: is it worth it? Is it going to work? Is it the right approach? And we've got to do it all the more seriously as our constitutional court recently took a decision that refusing commitments also is something that can be appealed by the company. We used to see it more as a procedural step, and now there is a right to appeal the board decision not to accept the commitment. So we've got to be serious about, why are we accepting the commitments, or why are we not accepting the commitments? And to be able to explain why. So I think it's always good to start from reality, to start from the practice. And the right thing to do here is to self-assess our past commitments and whether they have worked. We have a nice case that we can use, that I can use to kind of explain the pros and cons, and that's the Google publishers' rights or related rights case I already mentioned, where we have a sequence of decisions starting in 2020. 2020, we took interim measures to force Google to negotiate with publishers. So the starting point was French law was mandating a fair remuneration of articles being posted by Google on the search engine. and being accessed by users, and Google had decided that the price was 0 to make it simple. So we took interim measures to force Google to negotiate in good faith. The year after, 2021, we fined Google 500 million euros for not implementing the interim measures. And then we started a discussion on possible commitments. The commitments were accepted in 2022, and it's about a framework to share information with publishers and to organize a discussion with an appeal process in case there is a disagreement between Google and the publishers. So we created this negotiating framework, basically, using competition law to make sure that the discussion would be fair and to strengthen the bargaining power of publishers in front of a dominant player that was Google. And then earlier this year, we fined Google as part of a settlement for violating their own commitments. We found that they had violated 4 of their 7 commitments. And we came back to the sanction tool, the fine tool, and we settled with Google and we fined them 250 million euros. So in total, it's already 750 million euros that were fined on Google. And so it's an interesting case. What are the lessons? The lessons are, first, you've been very careful when crafting the commitments or when accepting the commitments. They have to be realistic and implementable, but they also have to be relevant in matters that are very technical. And here the role of the trustee is very important. So we appointed this trustee in charge of monitoring the commitments. The trustee is paid by Google, by the way, but reports to us. And you need to have the right, I mean, you need a competent trustee to monitor the commitments, but you also have got to make sure that the commitments will be implementable. And here, the market testing of the commitments is very, very important before they're being accepted, because they have to make sense. And then, yes, it's resource intensive, so that's part of the downside, that it takes a lot of resources to monitor, including, by the way, the sanctions on Google for not implementing the commitments. Even that absorbs resources, no? Because the case handlers that were in charge of that step of the procedure, they weren't doing anything else. So they were distracted from investigating on other cases. So we did it fast, but still, every time of the process consumes resources and can distract you from new cases. By the way, it's interesting to see that one of the 4 instances of violating the commitments was for failing to inform the trustee, Google failing to share the right information with the trustee, and this we sanctioned and we fined. I guess the bottom line here is that it's a learning curve. We would have wished this learning curve to be steeper, but it's steep enough in the sense that we've now created an environment where contracts are being agreed between Google and French publishers with increasing amounts of related rights being distributed by Google. So we've started this process. It takes longer than we would have wished for, and we had to use the full range of our instruments, including coming back to sanctions. And so I guess the last conclusion here is, yes, commitments can work, but they need to be made credible by the other instruments that you can still use. So the commitments operates in the shadow of sanctions. And that's what we had to do with Google, and we'll do it again, by the way, if need be. I hope not, but that can happen again. So I guess it's Theodore Roosevelt who said, be soft and carry a big stick.
Thank you. So Marisa, as technology-driven markets change rapidly, competition authorities need to adapt quickly, of course. So what are the main challenges that competition authorities encounter when designing remedies to restore competition in rapidly evolving markets?
Thank you for the question. So I'm going to make a link a bit with what Benoit was saying, because when we are speaking about remedies and when we are speaking about for me, remedies, commitments are part of remedies as well. I want, before I go straight to your question, I want to share something. In the Spanish Competition Authority, one of my deputies is dedicated to monitoring compliance with past decisions. So we have specific staff that the moment the decision is made, taken, adopted, then they take up to make sure not only that the fine is paid, but also that the commitments or conditions imposed in mergers, in antitrust, whatever, are followed up. So they would prepare some reports, interim reports up to a point to see how things are progressing, and in the end there will be a final report if everything is okay to say, okay, we can close this monitoring file because they have complied. If not, the law foresees that non-compliance is a very serious infringement, the same as a cartel, which means that then because of not compliance we can directly impose a fine. So I think that's useful, and that makes us all the time, because we have to monitor, it makes us think about it when we are designing you know, the remedies, whether they are commitments or whether they are other types of remedies, because we know we will have to follow up, so we need to check whether they are implemented. So it's also an obligation upon us. So for Article 102, I have to say that you could also think about structural remedies, which are not something that you cannot think of. So far, we have not used structural remedies, also because of the duty we have to try to impose things that are proportionate. So whenever it is possible to tackle something in a way that is, you know, less heavy on the companies, we try to do that. But it is true that it has to be also less heavy on the authority that has to check on that. So there may be a moment where we will have to, you know, go to structural remedies. So before, I already spoke about an example with the lenient of things we had requested, like this elimination of an exclusivity clause, or the question of marketing something. I have to say that this drug is for an orphan. It's an orphan drug, so it means that it is for a sickness that is very serious, and it is very important that the people do get that, you know, for chronic treatment. In other opportunities, what have we done as examples of remedies? So we had a case that is Royal Canine Society of Spain regarding the export pedigree certificate for dogs, and also competitions of dogs, the judges and all that. I will not dwell into the case because it would take too long, but it is just to say, what did we design as remedy? Well, there we ordered to facilitate access to the export pedigree certificate for breeders registered in the stat box of officially recognized competing associations, competing with the incumbent, the one that had the dominant position, whenever they would request it. So it is, you know, it's something easy to do in principle, and is easy to also monitor. In the case of Ecoembes, that was a commitment decision. We had these interim measures, which are also kind of urgent remedies while you are making the main decision. And there, now they have set up a full system, you know, to do the auctions. But in between, we imposed on them to use a public notary to scrutinize the auctions as they were making them, because we thought that there was a lack of transparency, of traceability of what they were doing. So we inserted the notary in the process, and some obligations to make accessible the format of the tenders, the conditions of the tenders, and you know, a number of things. So that lasted until the moment where we took the actual decision. So what do we impose most often as remedies? One is to eliminate in unilateral conduct. Eliminating exclusivity clauses, that has come in several cases. We have had limiting, tying, and bundling, which goes sometimes with exclusivity clauses, sometimes not, that we have had several times, including also in mergers that then had an effect on the position of some of the companies. This duty to market that I mentioned, the order to grant access or to recognize others, and Then we are thinking of other possibilities in new, in prospect cases that probably I will be able to present another time. But then to finalize this, we take this compliance very seriously, or not compliance very seriously. So in 2022 we had 2 cases for breach of commitments, and in 2023 we have opened 4 cases as well due to breach of commitments, and we are be certain that we are following them up. Thank you.
Thank you. Melanie, innovative remedies, again, we have to go into this subject, but are essential in digital markets? Are these areas often challenging traditional regulatory also approaches? Could you provide examples of innovative remedies that have successfully addressed anti-competitive behavior in digital?
Well, thank you for the question, Camilla. I would answer that with just 3 examples that I came up with an eye to 3 ideas, for what they're worth. The first is this eye to balance, as I've talked about already. The second is that I think sometimes we can get overly enamored with the complexity of digital. I think sometimes, not always, but sometimes the remedy in digital really doesn't need to be different in kind from the remedy in our traditional, more familiar industries. And then finally, just the importance of listening to the market, recognizing that as expert as authorities are on the boundaries of legal conduct, maybe not the best, highest use of the agency to pick winners and losers. So if what is being contemplated as a remedy seems to go against signals from the marketplace, that maybe that's time to step back and consider if it's the right remedy. So my first remedy that I was going to touch on was the case I mentioned earlier, which was against the Toronto Real Estate Board. Basically, in today's parlance, they were a gatekeeper. They owned access to the multiple listing service, so the accessibility to the world of listings of properties for sale. And they had members of the multiple listing service who had passed exams and paid them fees and had invested, therefore, directly and indirectly into the value of this service. The difficulty was, however, that those governing that gatekeeper marketplace were putting exclusionary rules around what their own members could do. So it wasn't, we were not talking about what people who were not members could do with information that they were posting, but rather what their very own members could do. And as commissioner, what I was concerned about and what my successors very successfully continued to pursue after I left, what we were concerned about was that the rules that they were promulgating with this authority and control over their members were in fact anti-competitive. And what they were doing was sort of quaint now. I mean, technology has passed us by, so these facts sort of sound funny. But basically what they were trying to do is they were very worried about big tech inserting itself between the relationship between their bricks and mortar agents, if you will, and their customers. And so they were very worried about allowing even their own members to post certain information about the properties on, okay, here it comes, a password-protected website. And so that was actually a big deal at the time, because what the rules required was that agents could hand you a piece of paper that had the information about what that property was last sold at, et cetera, some things that you really want to know if you're looking at a property. They could fax it. They could send it by carrier pigeon. They could phone and tell you, but they couldn't put it on a password-protected website. And so our concern was that actually we had innovative members who wanted to provide consumers with information they wanted in an efficient way, and they were being prohibited from doing so. And so in the end, as I mentioned earlier, it was very difficult to prove, in fact, virtually impossible to prove the effects per se, because there was no competitive platform to the MLS. But what the tribunal was ultimately satisfied with, the anti-competitive intent was so clear and obvious that they found enough around effects in terms of the prohibition of innovation in the future that they actually issued an order requiring those rules to be stopped. As a result, the information about sold prices is much more readily available in the Canadian market, or at least in the Toronto marketplace, and it has expanded given that that's the largest market in the country. And I guess the point is, why was this successful? In my view, I think it's really important that it didn't overreach. What the remedy did was prohibit the promulgation and enforcement of rules that were preventing competition. But what it didn't try to do was to open up access in all terms and in all ways to anyone who would want to play. If they had done that, of course, they would have destroyed the value that had been invested in developing this very valuable network that allowed consumers and agents to interact and allowed property and information to be known, and it would have destroyed the entire value. Again, you know, I just think that's a good example of walking that fine line between protecting and safeguarding incentives to innovate while at the same time addressing effectively anti-competitive conduct. My second example is really, again, as I said, the remedies don't necessarily have to be all that fancy or different. Things that we wouldn't tolerate in a traditional marketplace, we can address in ways that we, I think, can also address in digital marketplaces, sometimes admittedly. And I'm talking here with reference to the 2022 resolution by the Bureau of a case against Turo, which is a car-sharing platform. And they had in place rules that said, if you want to put your car on our platform, you can't put it available on another platform. So relatively straightforward. The matter was resolved. I in no way had anything to do with it, just read about it, but it was resolved by Turo changing their terms and conditions and allowing folks to put their cars, commercial or individual, put them on multiple platforms. And so, you know, as I said, it's not really different from a traditional market insofar as we would never tolerate a hypothetical monopolist of a physical marketplace prohibiting vendors there to sell their stuff in other stores, right? So I guess the point is we don't always need to be too fancy, and maybe the simplest solution may be the most effective. And my last comment is on a case that isn't actually technically a unilateral conduct case, and I wasn't involved personally, so, and I have no view about the merits of it, but it was actually a mergers case, and it was sort of a 4-3 in our telecom space, where the real overlap between the two parties that were merging was in the mobile phone space. And the parties came up with a resolution, whether that was effective or not, I really don't take a view, but that they were going to divest the mobile business to a regional player. And what I think is interesting from a remedial perspective is that that buyer, that divestiture buyer, went to you know, one of the parties that was left standing to negotiate terms for access to spectrum and all these various things they need in order to be able to effectively operate the mobile system. And they, as a sophisticated player, came up with basically their own behavioral remedies. Like they negotiated ex ante terms and conditions on which they would have access at their choice to space on the wires, if you will, to effectively operate their business. And the Bureau did not like the terms and conditions of those agreements and took the view that this company, a sophisticated player, had negotiated for itself and was paying a lot of money for it and felt it needed these terms and conditions to protect itself, that they didn't know what they were about, that the Bureau knew better, and that those terms and conditions were actually going to drive this divestiture buyer out of business. Again, I don't take a view whether that's right or wrong, but I think the point is that it's important to think about, you know, listening to the market. I think we can take a few lessons out of this. Number one, do think about your buyer, because there would have been buyers for sure who wouldn't have been sophisticated enough and that the Bureau should have been looking out for in that particular sense. So look at the buyer. Is it a sophisticated player? Might it know what it's about or not? Secondly, I think it's important to consider whether you're going to have to monitor the remedy, right? If you're not going to have to monitor it, it makes it a lot more attractive, right? And in this case, there was a regulator in the space. There wasn't going to be a requirement for the tribunal or for the Bureau to monitor it. And then finally, my point about listening to the market and testing the market. It can be a really good sign if the competitors really hate the idea. Probably there's a reason they hate the idea. That's because it's pro-competitive. And likewise, if in this case the divestiture buyer thinks it's going to be good for its business and it's going to be able to be a success, take that into account as you balance all the factors that I know the really hard job is to do as you're designing remedies. I just encourage you to take that into consideration. Thank you.
Thank you. Hiker, digital platforms have transformed market dynamics, showing that even without dominant market power, they can still impact competition negatively. Observations suggest that unilateral conduct by digital can raise competition concerns, even in the absence of established dominance or substantial market power. In your opinion, what strategies are competition authorities considering to address these challenges effectively?
Well, thank you for the question. I know we're running out of time, but I just want a very quick comment on remedies and just underline that the DMA also includes structural remedies as part of the enforcement. It's worth mentioning. But to the question in general, I'd say that the competition rules have been shown to be flexible and capable of addressing new business models, technological developments and market conditions. But the issue you raise is definitely a valid one. And in our digital market sector inquiry that we conducted a few years ago, we found that the market power of digital platforms is not always best captured by the classical concept of dominance. We found that the digital platforms can become an unavoidable partner to business users that want to reach certain customers, and that this might grant the platform significant intermediation power, even though its market share is well below the thresholds typically required for dominance. And in these cases, market definition may become crucial in order to fully capture the competitive dynamics. An example of this is our Nasdaq case, as I mentioned, where the relevant market was defined on a platform basis rather than individually for each user side. This allowed us to properly account for the market power possessed by Nasdaq and the potential effects of the conduct in question. It is also worth mentioning, at least keeping in mind, that the rules on anti-competitive agreements also allows us to intervene in situations where a digital platform's anti-competitive conduct results from its agreement with business users, even though there is no dominance. An example of this is our two cases a few years back against Booking and Expedia concerning their use of price parity clauses. But as we note in our sector inquiry, in cases where platforms have strong intermediation power, despite a relatively low market concentration, there is a risk that the anti-competitive practices can't be addressed by competition enforcement within the scope of existing competition rules. And this kind of scenario, as well as many other potential structural or systematic competition problems that can't fully be addressed by the existing competition prohibition, has led us to believe that there is a need for a new competition tool to complement the existing ones. And recently, the Swedish government decided to open an inquiry into the question of introducing new tools. And we expect this inquiry to report back at the beginning of next year. But I should point out that in our view, based on our market studies, it would be beneficial for these new tools not to be limited solely to digital markets. We have observed structural problems in many markets. For example, the market for building materials. So a new tool should be broad in this respect. That's our view. Thank you.
Perfect. So we are out of time. Thank you once again to our distinguished speakers for the contribution today. We've heard perspectives ranging from private views in Canada to competition and experience authorities across Europe and the political sphere from Mr. Andreas. So I thank you all for the participation and for a very insightful view, and good morning.
Thanks again to all speakers. Have a photo with all together, all right? We will continue with the second plenary of this morning. Thank you again. Obrigado, tem a escada aqui se preferir. We will continue with the second plenary of this morning, ICN implementation. Please welcome our moderator to the stage, Paul O'Brien, Counsel, Federal Trade Commission, United States of America. Mr. O'Brien. And I would like to invite to join the panel the speakers, Jean Pratt, Senior Deputy Commissioner of CB Canada, Yehan Grigoryan, Chairman of Competition Protection Commission, Republic of Romania, Mahmoud Mumtaz, Chairman of the Egyptian Competition Authority, Egypt, and Maria Elena Vasquez, President of CNDC, Dominican Republic. Yeah. Yeah. I called him. I haven't got this name here. Susanna. Spain. She's not here as well. She's not here. Yeah. So it's Joel Abraham from Fiji. Abraham from Fiji. From Fiji. 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 No, Fiji. F-I-G-J. I'm sorry. Fiji. F-I-J. Fiji. F-I-J. So that's the competition. All right. And Susanna. She's here. She's all right. Susanna Campagna. She's already Susanna Campagna. Yeah. Campagna from Spain. Yeah. And then now Joel. Okay. All right. Thank you very much. We have other names right now. Susanna Campagna from Spain and Joel Abraham from PGF IEGI competition. Now I pass the floor to Mr. Paul O'Brien.
Bom dia. Hello, everyone, and welcome to the ICN Implementation Panel. My name is Paul, although this week I'm happy to be Paulo. And I'm honored to be joined by distinguished representatives from Armenia, Spain, Fiji, and Canada. This panel asks one of the most difficult questions in the ICN. How do you use the ICN? This is a hard question, not because there are no answers. It's a hard question because there are so many ways in which ICN member agencies, and yes, NGAs, I'm looking at you too, participate in the network and take away from the ICN. We ask this question: how do you use the ICN regularly to help remind ourselves and ensure that the ICN and its work is meeting the needs of its members? Quick context for our panel. Now, as we all know, the ICN is an informal, voluntary, non-binding network. Members choose to use the ICN and its work product in ways that are relevant to their needs. So why do we even care about implementation, you might ask? Well, implementation within the ICN refers to efforts that we do to promote ICN work and offer support to members who are interested in learning more for their own consideration when they may establish new rules or practices. So today our panel will share stories from their own agencies that made the choice to be active in the ICN or use ICN resources. We're grateful for their time and willingness to inspire us today. Now, I must confess that my remarks are my own, and they do not necessarily reflect those of the FTC, the ICN, CAGE, my fellow panelists, or even proper Portuguese. Quick point on format for our panel. As is tradition, we've integrated into the format of our panel a tribute to our hosts at CAGE and Brazil. The panel planning committee used the wisdom of Brazilian proverbs to convey our message. The wisdom of Brazilian proverbs is sincere, even if at times I may sound like viajando na maionese. I am traveling in mayonnaise, or not making any sense at all. We also celebrate ICN legend Randy Tritel, as he first used home country proverbs woven into his remarks years ago and made a tradition of them at the ICN. And much like Randy, they are always clever and gracious. And speaking of ICN legends, I would be remiss if I didn't honor Cynthia Lagdameo, who couldn't be with us this week for her support across not only this week's agenda, but the ICN. Well, I confess that our panel planning was a bit bumpy at times. Our first inspiration came from a lovely Brazilian proverb, uma ararina so não faz verão. A single swallow bird does not make a summer. This perfectly sums up the idea that working together is more productive than working alone. It's an underlying theme of the ICN itself, and indeed implementation, where we learn from each other what has worked well in other places. This proverb pairs nicely with another one that talks about the dangers of being unprepared. Now kuteke a onça com vara curta. Don't poke a jaguar with a short stick. Doing something dangerous, like enforcing competition laws without being prepared, can be a bad idea. But the ICN is here to help with bigger sticks. But that got us thinking. Implementation and convergence can be hard, never-ending work. And there are a lot of jaguars out there. We were discouraged. We even asked, how can we descascar abacaxi, peel a pineapple, or here, tackle a big problem? One of our planners even suggested tirar o cavalinho da chuva, take the horse out of the rain, or to give up. Oh no, I started to fear as a moderator. Someone even said, a cobra va fumar. The snake is going to smoke. In other words, the situation is about to get ugly. But no, we got new panelists, and instead, we sought deeper inspiration. Why do we strive for convergence even if it's hard? The answer came to us through another Brazilian proverb. Agua mole, pedradora, tanto bache ate que fuera. Soft water, hard stone, keeps beating until it gets through. Indeed, the ICN's mission to promote convergence continues even in the face of challenges. Well, it's time to turn to the core of this panel, and indeed the core of the ICN experience. We're going to hear stories from our panelists and how they use the ICN. I'm going to start in Armenia. Jared Gavargan, please tell us about the CPC and its participation in the ICN.
It's working. Thank you, Paul. Dear colleagues, first of all, I want to start from saying thank you for Kaje for this warm, very warm hospitality in this nice place. It's my honor to share with you the brief information about the directions of the Commission's current activities and present the engagement of the ICN and usage of ICN working papers in our work. I want to talk about strategic document. Now the Commission is currently developing his new strategic document, which will present the directions of the Commission's work, goals in these areas and the activities that shall be implemented to achieve our goals. And the document will be designed for the next 5 years and will outline provisions for each specific year. The effectiveness of
Dois, som. Yeah. And the microphones? Can we test right now?
Thank you. I'll bet you there's a good Brazilian proverb for this, but I didn't prepare for that. So please continue.
Here we are, yeah. And okay, about our strategic document. And, as I said, it's for the next 5 years, and we outline priorities for each specific year. The effectiveness of the strategy and the results achieved will be presented in the Commission's annual report. And in this context, the report on the ICN agency's experience in gathering and using information for effective strategic planning was very helpful in shaping our strategies. This report allowed us to understand the trends in the developments of strategies in the field of protecting competition and consumer rights among ICN members. And namely, we studied common timeframes for strategic planning, the key information sources, and the specific areas our experienced colleagues mostly prioritize. And moreover, Commission reached out the representatives of the authorities mentioned in this report and received more particular information. This led to valuable exchanges, including access to various strategic documents and ongoing support in our strategic development. And thank you, specific thank you for these authorities for their assistance and support. The next document, which designed its advocacy strategy for CPC, and it is worth mentioning that regarding the Commission strategic planning, we are working on this strategic document and focusing on competition advocacy. And this document will outline the key messages for each area of Commission's activities along with the main methods for effectively communicating this message for specific audience. And yeah. In our approach, issues like abuse of strong bargaining power, the Commission maintains a unified message across various audiences like the business sector, business community, or academia. And we customize how we should present these messages to each group using suitable communication channels and formats. And for developing advocacy policy, we also use ICN reports and materials. And at the same time, several courses were conducted to enhance qualifications of our employees and our staff. And it's worth mentioning that substantial course documents were developed by various ICN working groups. Another example that Commission's activities were Commission every year annually examined 5 sectors or markets. It's a market sector inquiry, and the Commission developed a manual conducting sectoral inquiries among other sources using the 2016 ICN Market Study Good Practice Handbook. And this manual explains all phases of market research, starting from establishing of the research team and to the final report and publication of the materials and sector inquiry. And this manual especially is important in the context of implementing and involving new employees in the market study process. And these new employees now have very accessible and simple guide for any stage of their work. And also part of this topic, let me to share information about Armenian merger assessment process. In November 2023, OECD approved Armenia's request to adhere the recommendations of the Council on Merger Review. OECD confirmed that relevant Armenian principles, legislation and processes are in line with recommendation principles. Now we are currently working for updating our guideline on assessment of mergers, and in this sector also we use ICN working group papers. In conclusion, I would like once again thank ICN for much needed basis for development of competition authorities and improving the level of competition. And it's more important, especially for developing countries and for new agencies. Thank you.
Thank you. I appreciate you sharing that with us. So much I loved about that. First of all, that you didn't let the IT challenge stop us. You got through that. But even that first story about agency effectiveness work, it wasn't only the work that you helped use, but you used that as a springboard, as connection to other agencies. And so much of that happens across the ICN. It's great that we hear a story like that. All right, Jean, I'm going to turn next to you. If you could tell us a little bit about what the Bureau gets out of ICN.
So I'll start by saying ICN work products, how do I love thee, let me count the ways. As you've heard from Melanie and other NGAs and representatives from Canada, we've been going through a period of, I will call it legislative renewal. Some of the NGAs may call it a revolution, but ICN work products were incredibly helpful to the Bureau through the competition policy changes that are going on in Canada. There's nothing better to lend credibility to your position on recommendations to policymakers than international best practices, and being able to point to something that says this is not a crazy idea by the Competition Bureau, this is actually well-established, recommended practice by numerous jurisdictions around the world. So we have used ICN work products in addition to the OECD products to advocate for changes to our law that we think are best practices. And in particular, we did reference the recommended practices for merger analysis and the recommended practices for merger notification and review procedures. As I said, this lends huge credibility to our advice to policymakers as an enforcement agency, and I think it's probably part of the reason that we have ended up with credible recommendations that are now that have been implemented and are now before Parliament for passage. So once we get the law, of course, we've had all these changes. We need to figure out what our enforcement policy guidance is going to be. And so the ICN work products will also be a great resource for our enforcement staff as we try to establish what our new enforcement guidelines will say in the areas of mergers, abuse of dominance, as well as our consumer protection work. So, you know, they are really great for us to look at, both as a resource to consider key questions on what our own enforcement policy guidance should be, but also for us, you know, when we're thinking about this, to see if what we're thinking about implementing may be out of alignment, or if there are questions we should be asking ourselves about nuances that would need to be put into our guidance. We do use the work products, the merger remedies guide, I think is one that I can speak to. We use that in addition to our existing merger remedy guidelines. We were part of the work to draft the remedies guide, and I can say it is used in our day-to-day work by our remedies unit, as well as our officers when we're looking through remedy design, and considerations when approving divestitures and evaluating divestiture purchasers, including thinking through some potential entanglements between the merged entity and the proposed divestiture purchaser, like transition service arrangements. So then, we've got our law, which the ICN work products have helped. We're going to use it to provide enforcement policy guidelines. Then we were also lucky enough to have an increase to our budget, so we have all these new staff, and we have a lot of very busy enforcement staff who are also the ones who generally do our onboarding training, and so using the training, the ITOD modules on demand has been a key tool for us to make sure that we're using efficient use of our senior enforcement staff to teach the practical, more advanced topics in our work, and using the ITOD modules for the onboarding of our staff to get a general grounding. So staff in my branch, every single one of them, when they're new, will watch the series on competition fundamentals, dominant firm conduct, the series on mergers, and the series on investigative techniques. And we also do recommend the series on horizontal restraints, state impediments to competition, agency effectiveness, and competition policy. So soup to nuts, I think we use those ICN work products day to day, from enforcement policy, competition policy, to day-to-day work of our staff.
Thank you, Jane. That was wonderful. As you just said, I couldn't have said it better, but highlighting the different types of work that we have in ICN available, some of the guidelines, or rather the guidance and recommended practices level work that might inform changing practices, and then the staff day-to-day stuff. Again, my notes couldn't have been better, so thank you, Jane, for that intervention. I'm also told we now have 80 questions about how to get a budget increase, if we could talk about that later. All right, let's turn to Fiji next, and your experience with the ICN.
Yeah, thank you. Our experience, basically, before I talk about our experience, I think it's important to highlight why the ICN is important for a country like Fiji. Reality for us on the ground is, as an agency, I started when there was just 7 of us at the agency. And those 7 were largely dealing with regulatory matters and not with competition matters. And none of our universities teach competition law or any economics to do any assessment for competition related matters. That poses a challenge. Means when anybody walks out of university or walks out of the private sector, comes into the FCCC, it's incumbent on us to train the people. And it would be useful to train them if we knew what to do. So the starting point is you would have a case of the blind leading the blind. So the ICN really was a beacon of hope for us, in the sense that we were able to get people to say, okay, let's watch videos, let's go through the tools that's available. The 2021 CAP tool was one that we used to integrate into our strategic plans. And we said, how do we look at incorporating things like procedural fairness? What does it mean? Because in a small state where like Fiji, where the regulator has been given quite a lot of powers. So in our act in Fiji, it says you can't basically take the regulator to court. So it's incumbent on us to ensure that we have procedures set out that is fair and transparent, follows the process of natural justice. And when we started looking at what we could do, we looked at our strategic plan and we started integrating the requirements of ICN integration. So one thing we did is we looked at strategy goal number 1, which was look at competitive markets. And here we are looking at how can we leverage experience and strategies that's related to anti-competitive conduct and merger controls. How can we enhance our monitoring capabilities? We looked at strategic goal 2, where we looked at consumers must be informed. Here we adopted and adapted ICN's CAP principles to enhance consumer protection enforcement, especially on procedural fairness and transparency. We looked at strategic goal 3, which is basically any regulatory intervention must be economically justified. Here we looked at ICN's resource to explore the potential benefits of international best practices, of economic regulation, and where they intersect in markets where competition is lessened or limited. And the principles and processes that shared within ICN provided us with benchmarks and guides so that we were able to have more effective regulatory frameworks that were aligned to international standards. And the last strategic goal we have is to ensure that FCCC is recognized as an expert agency. And so here, to strengthen our reputation as an expert agency, one of the things we did was, how can we improve and increase our participation into ICN? How can we contribute to development of international best practices? How can we do peer learning? So one of the things we realized we could do was peer learning. And I would like to thank Gina and the ICCC for always being there to provide that support. So whenever we would do a particular merger transaction or an acquisition transaction, we'd then take the entire report, go to the ICCC and said, guys, can you critique this for us? And so they would, so at the start they would start critiquing and say, you know, you could maybe look at it, I mean, this particular issue from this angle. You could look at this particular issue, oh, here you've done well. And that would be a channel of feedback for us. And as we are now in the process of doing our next strategic plan, we are looking at a few things on how can we develop and enhance relationship. How can we develop policy and guidelines? So one of the things we realized is it's not always about taking what we can or looking at taking all the resources we can out of the ICN. How can we contribute by giving something back? Now, I joined the commission when there were 7 of us. Now there's 96. I've basically seen the genesis of when we had nothing to now something. And right now we're in the process of putting up a guideline that will contribute to ICN on how do you start a young agency. Now, this is not to do with very macro level theoretical procedures. This is basically, okay, this is a board charter. This is how you write a board charter. These are templates you can use. These are performance trackers you can use. So these are actual templates that we use at the FCCC that we're saying, look, we've made this. Now let's share it with anyone that can make good use of it. Because when we started our journey, the ICN, I mean, nobody knew how effective it was for us. But in a country where you constantly have people leaving and the allure of Australia and New Zealand and migration out of Fiji, last year alone we've had about 70 to 80,000 people leave Fiji for the Australian New Zealand markets. So we're constantly losing people. And so how do you train them? And the only way you can train them is by saying, look, here are the resources. And in Fiji we use a concept of, you know, when you're not an expert in a subject matter but you still have to do it, you become a bush practitioner. So while I'm an accountant by profession, we had to become bush economists and bush lawyers. And so what we may not be competition experts, but by looking at all the resources that's available through the ICN network, we're able to bring ourselves up to speed. And I am glad about 3 years ago when we eventually went for peer review exercise, the ICCC said to us, can you share this with us? This is really good work that you've done. So we can see the benefits that stems out from a network like ICN. And for agency that has nothing, no resources, nowhere else to go, the ICN is like lolly land for us.
Thank you so much. It's wonderful to hear these stories where you're integrating ICN participation into your strategic plan for your agency. I think we now have 80 questions about when the next ICN event in Fiji is, I'm told. All right, so our last panelist, Susanna, thank you so much for joining us. Your story, I love all these stories, but your story in particular is near and dear to the hearts and minds of some of the newest colleagues at competition agencies across the world, and indeed the ICN. Tell us about technologists and data scientists' involvement in ICN.
Yeah, thank you very much. Yeah, about the new technology groups, and it's a new, I think it's the new baby of the ICN because it's an initiative that arose in the last year, and mainly thanks to Paul's efforts and Paul's team efforts, because it was his initiative, I think, personally. So thanks for that, because you know that I'm quite enthusiastic about it. Thank you. And this group, I think it's a confirmation that the reason that goes behind the creation of this group, I think, is the confirmation that competition agencies have changed, or has to change, all of them, because of different things that are now in the new wave of the reality. First, because of the digitalization of all the economies. That's something that have been said yesterday and all the day today. Second, because of the amount of data, because nowadays there are much more data. And third, because there are new deployments of new technologies and new developments, new tech developments. And I've heard quite a lot of times yesterday and today how these developments, how these tech developments could be a problem for new competition infringement, and that's true. But I think that the tech group, it's on the contrary, yes, on the bright side. It's how can we build or can we profit from this tech developments on these new tech deployments to get new enforcement cases. And that's the philosophy of the tech group, to put together new profiles of the competition agencies, not only lawyers and economists that are quite good, but for instance in my unit we have data scientists, data analysts, IT people, I have aeronautical engineers, mathematicians, statistics, I mean different profiles, and also but also they have expertise in competition matters. So with all of that expertise, you can create quite good ideas and quite good technologies that are really helpful. And the idea of the forum is to put together all the different authorities, for those that are really in a very high stage of development of these new tools, and for the other ones that maybe are not yet in the best position. But the idea is that all of us, we could help each other. And actually it was, because we had a meeting in March and in Washington it was, and in a humble opinion, I think that it ran quite well. I said in that meeting, in my personal opinion again, you learn more about the failures rather than from the success. And I had a lot of failures, and quite a lot of them, and I could tell that to the other units. I've been running some projects for more than 10 years, so I could tell to the other people or to the other units, do not do this because this is not going to work. So I think it was quite successful in that sense. So the profiles of these meetings, at least in the Spanish case, we are going people from the competition directorate, in my case from the economic intelligence unit, and also from the IT unit. There is more horizontal, I don't know in other agencies. And for the results, as I said, it was quite positive because of the synergies created between all of us. Also after some bilateral contacts that have been made. And also it was a common statement from all together. And yes, and I will make also a clickbait, because I could develop more these ideas, because I have also a breakout session later. So if I have more time later, if you want to go on into details, I could do it later.
Thank you. That was wonderful. Yeah, it was amazing seeing a new constituency within the ICN. Sort of form and learn from each other. Look, you may be sitting there and be a bit of a garage pao, I have a wooden face, or you may be a cynic. We know that implementation is not always mamao con azúcar, papaya with sugar, or a piece of cake. In fact, some of our cynics on our planning committee said, pimenta nos ojos dos otras e refresco. Pepper in the eyes of others is refreshment. And indeed, misfortune for others can be a bit entertaining sometimes, but we can also learn from those mistakes, as Susanna just said, and that's the intent for for implementation. So we have arrived at the end of our Brazilian-inspired advice. I know you want more, but after the great stories you've heard already, you might say, you know, why did you have the smallest panel of the week? Well, I'll tell you, a Brazilian proverb has the answer. Para bom entendedor, meia palavra basta. For the wise, half a word suffices. So we hope that you use your wisdom to be inspired by these stories. Think about your own agency's use of the ICN and its work, and share your own stories this week, the coming year, and maybe next year's implementation panel. I feel like sometimes the entire week is sort of an implementation panel. Such a great example yesterday, I was reminded Jorge from FNE talking so eloquently about some of the work they've used in their agency on another panel. So finally, obrigado to Kaje, especially Alessandra, and all of the gente boa people at Kaje who helped put this together. The conference is linda maravilhosa e boa pra caramba. Thank you all.
Thank you to all the speakers and the moderator as well. Thank you very much. Let's just have an official picture. Well, I invite you all to our 30 minutes morning coffee break, and you can attend the breakout sessions of your choice. After the breakout sessions, all are invited to a lunch which will again take place at the arena. At 2 p.m., we will continue with round 3 of the breakout sessions. Ladies and gentlemen, welcome back. I hope you all enjoyed the breakout sessions. Our next plenary session was organized by the Advocacy Working Group. They will discuss conducting market studies to understand competition in emerging markets. As a moderator, Kenneth Tanate, Executive Director of Philippine Competition Commission, PCC, Philippines. Mr. Tanate, the floor is yours.
Yeah, thank you. So good afternoon to everyone. Again, I'm Kenneth Tanate from the Philippine Competition Commission, and I'm honored to moderate this plenary session on conducting market studies to understand competition in emerging markets. Foremost, I would like to thank President Alexander and his CAGI team for arranging and hosting this event in a very nice location. So before we start our this session discussion, allow me to take this opportunity on behalf of the Advocacy Working Group co-chairs from the competition authorities of Japan, Kenya, Egypt, and the Philippines to promote the Advocacy Working Group ongoing activities. So first, we have the study on assessing progress in the development of successful advocacy strategies to the judiciary, which is being led by the Guernsey Competition and Regulatory Authority. So the draft report has already been completed and will be circulated among the Advocacy Working Group members for further input. And the second initiative is the study on evaluating effectiveness of advocacy initiatives, which is being led by the Philippine Competition Commission. And the report is already being drafted based on the information gathered from the Advocacy Working Group workshop in Kenya last February. And we hope to finalize the draft for approval in the third quarter of this year. And the third study is on the interactions between sector regulators and competition authorities, which is being led by the Japan Fair Trade Commission. The survey questionnaire for this study is being prepared for dissemination in the third quarter of 2024. And as you know, part of the mission of the Advocacy Working Group is to facilitate experience sharing among ICN member agencies. And through the ICN World Bank Advocacy Contest for this year, which is being facilitated by the Competition Authority of Italy and the World Bank, the winners of these contests will be announced right after this session. So please stay tuned. With that said, I'm requesting your support for the priority initiatives of the Advocacy Working Group. And if you have any suggestions on what priority products you want the Advocacy Working Group to focus on, please don't hesitate to contact the Advocacy Working Group co-chairs anytime. Now to start our session discussion, I would like to welcome our distinguished panelists. First, we have Commissioner Saverio Valentino of the Italian Competition Authority. He has been a board member of the Italian Antitrust Authority since June 13, 2023. And before his appointment at the authority, he worked as an attorney in private practice, mostly focusing on Italian and EU competition law, appearing before the Italian and EU courts of law and in various competition authorities across the world. Second, we have Chairperson Ravneet Kaur of the Competition Commission of India. She joined the CCI as chairperson on May 23, 2023. She has rich and varied experience of working with the government of India and the government of Punjab for over 34 years as a member of the Indian Administrative Service. And third, we have Commissioner Songsam Kim of the Fair Trade Commission of South Korea. Prior to his appointment as the Standing Commissioner of KFTC, Songsam rose from the rank in KFTC, holding various positions from Director for Planning and Budget since 1996 to Head of Seoul Regional Office in 2018, and Director General for Business Trade Policy Bureau in 2021, among other positions. And last but not the least, we have Ms. Lucia Ojeda, the non-governmental advisor of COFESA in Mexico. Lucia is specializing in economic competition and regulated markets. Her expertise spans a range of sectors, including telecommunications, food, pharmaceuticals, auto parts, retail, iron and steel, and railroads. Now, our session topic, note that given the advancement in technology within emerging markets, competition authorities and sector regulators are facing challenges on how to enforce the law or develop smart regulations. Thus, it is paramount to have a good understanding of these markets. So just to mention briefly, during our roundtable discussion on how DMA-like regulation could shape the future of digital markets, which was organized actually by the Competition Policy International last Tuesday, the discussion touched on what would be the appropriate strategy of your agency. Are you going to take a wait-and-see stance or a proactive stance? And one of the proactive strategies mentioned is to conduct a study to understand the market and competition issues better. So this session would explore how market studies could help build that understanding to deliver dual benefits. One is to inform advocacy for government agencies in relation to the need for an effective regulation in these markets, and two, to inform competition authorities for its own enforcement mandate. And we will have 3 rounds of discussions for our panelists to share their insights and experiences, covering 3 subtopics. Number 1 is the identification and scoping of studies in emerging markets. Number 2 is discussion on the methodology and practical approaches in conducting market studies in emerging markets. And the third one is the discussion on the application of results and engagement of stakeholders. So without further ado, let's start with the first round of discussion on the identification and the scoping of studies in emerging markets. So I'll start with Saverio. I note that the Italian Antitrust Authority has carried out over 50 sector inquiries since its creation in 1990. Kindly share to us how AGCM identified the scope of studies or sector inquiries. What mostly triggered the sector inquiries? Saverio.
Ken? Okay, now yes. Thank you, Ken, and thanks a lot, particularly to Kaji, to Alexandre for organizing such an amazing event. Muito obrigado. And to reply to your question, yes, indeed. The first sector inquiry conducted by the Italian authority dates back to 1991. And since then, the Italian authority carried out 56 sector inquiry. Actually 55 completed, 1 is still ongoing. The law says that we can carry out a sector inquiry in economic sectors in which trade developments, prices, or other circumstances seem to show that there is something that distorts or prevents competition. In practical terms, over the years, the authority selected the sectors that should be the subject of a sector inquiry based on a number of factors. At the beginning, particularly during the 90s and the beginning of the year 2000, we took into account the fact that before we had in Italy a lot of monopolies, a lot of state monopolies, And those following European directives or decisions of Italian government, those markets were liberalized. So there was an introduction of competition in those markets. Sector inquiries were an extremely helpful means to understand how that liberalization was working and whether additional measures were necessary. So to ask the government or parliament to intervene again to improve the liberalization, or possibly to intervene, to allow the authority to intervene itself with its own investigation. Sometimes sector inquiries are prompted by very high prices, and that's what happened last year in motor fuel prices. And so there was we had the sector inquiry just to check whether these what were the reasons that prompted this sudden increase in prices of motor fuel. There are also in several occasions sector inquiries that relates to that may benefit other sectors, not only the competitive dynamics, but other other sectors, other interests that are relevant from a public standpoint, such as the protection of the environment, and we had an inquiry on municipal solid waste management in 2014, or the protection of public health, and that's why we had a sector inquiry on vaccines for human use in 2016. Some of the sector inquiries carried out by the authority can definitely be defined as concerning emerging markets, at least at the moment in which they were launched. In 1992, quite far away in time, we carried out a sector inquiry on mobile cell phones. In 1993, we carried out sector inquiries on transmission of data. Of course, data transmission in 1993 was very different from data transmission nowadays, but still was definitely an emerging market, and also high-speed railway sectors. More recently, just in 2017, the authority carried out a joint sector inquiry together with our regulator, privacy and telecommunication regulators, on big data. And that sector inquiry in 2017 already wanted to investigate the functioning of algorithms. So, there is even a mention about AI, so the increasing importance of AI. In 2017, nobody could think about how important AI would have become in just a few days afterwards, but still it is mentioned in the report concluding our sector inquiry. Just to finalize my answer to your question, in any event, we have to take into account in selecting the sectors that must be the subject matter of a sector inquiry, that the authority has limited resources. So we have 320 officials, more or less, and our core business is conducting antitrust investigations and consumer protection investigations. So to devote time to sector inquiries, we subtract time from the core business of the authority. However, since the authority truly believes the sector inquiry are important, market studies are very important, when there was a reorganization of the authority at the beginning of 2023, a new directorate for market studies, sector inquiries, was created. Now it has 7 people, and the creation of a specified directorate for this purpose shows the importance that the authority gives to these studies.
Just quickly follow up. Are these sector inquiries were conducted based on complaints or motu proprio? Just quickly.
not really complaints of interested parties. Sometimes it's politics, there will be media attention, but more often really the sector inquiries are started ex officio. All of them are started ex officio, and based on what the authority believes it's very important. As said, the liberalization, the follow-up to the liberalization was a very, very important reason for the sector inquiry. Then, of course, the big data sector inquiry, in 2017, there was a lot of media attention concerning big data, and so that's why it was decided to carry out, together with other regulators in Italy, this important market study, which resulted in a joint report of the three authorities.
Yeah, thank you, Saverio. That's indeed worth 3 decades of experience. Now I'll move to Chair Ravnit. Tell us CCI's experiences in conducting market studies for purposes of enhancing understanding of emerging markets to effectively enforce competition law.
Thank you, Ken. We have in fact been using market studies largely for emerging markets, which are new markets, where the intention is to, look at the knowledge gaps, try to identify, and you are not able to have very reliable data. So you need to go back to the stakeholders, get a deep dive into how the sector is working, and then try to uncover in case there are any competition concerns. So the way the Commission has been working in the past is that we have been doing market studies with the sectors which are coming up, like maybe an e-commerce sector, or there could be even the cab aggregator industry, which was a cause for some concern. There were some media reports coming in that there are competition concerns. Then we also now recently in the process of starting a study on artificial intelligence. In fact, the RFP document has been floated, and we should very soon be looking at getting the bids from various third parties. By and large, the way the Commission has been looking at market studies is that the Commission needs to understand a particular sector in greater depth. So the market studies have been conducted through implementation partners, the mechanism which is followed. We have a list of agencies which are identified, which are research institutions which we would like to associate with, and there could also be an open tendering process. So this is basically meant to facilitate the Commission in its work. It is not intended to start a probe. So that is not the intention with which it gets started. However, there could be some recommendations which do get acted upon later on.
Yeah, thank you. That's very interesting. And now I'll move to Song Sam. Kindly share to us some recent examples of market studies conducted by KFTC, especially on cloud services, maybe semiconductor or OTP, the over-the-top platform. Song Sam, please.
Before starting the explanation, I would like to say that I'm very honored to discuss the topic, competition advocacy, with many renowned experts in competition law here today. First of all, from a perspective of competition law, an emerging market that we are talking about can be defined as a market where anti-competitive conduct and the resulting effects are yet clearly identified. Competition authorities around the world have recently studied the AI market and the digital platform market, which are examples of such emerging market in my perspective. The KFTC also has been making continuous efforts to understand these emerging markets and to proactively identify the competition issue. Specifically, the KFTC has conducted market studies every year, such as the market for cloud service in 2021, IoT in 2022, and semiconductor and OTT both in 2023. This market study gave us key insight. Through the 2021 cloud service market study in particular, we found that the market is highly concentrated with a few global giants, including Amazon, and the market is prone to tipping due to the market characteristic, such as technology incompatibility and data concentration. That might mean competition is likely to be limited in domestic cloud services market. Based on these findings, the KFTC has been monitoring potential violation in the cloud services market. This year, we will look into potential violation of competition law in the OTT market as well, based on the OTT market study, which was conducted in 2023, as I mentioned earlier. As this experience shows, the result from market study can provide us insights for competition law enforcement leads for investigation.
Thank you, Song Sam. Now I'll go to Lucia. From the NGA perspective, what are the pressing topics in emerging markets that you want to read on? Do you think private sector must have influence on which topics competition authorities should pursue?
Well, first, indeed, it's a great honor to be here today with this distinguished panelists. Of course, thank you to Kaje for our host, and COFECE for the opportunity to be here. In the case of Mexico, it is relevant to explain the powers of COFECE to perform market analysis, because we should distinguish between market investigations that we call barrier to competitions, Article 94 of our law, market studies, and other advocacy documents. So, because each of them has different outcomes and sources. Market investigations could be resolved in binding remedies directed to economic agents and formal recommendations to other authorities. These investigations are initiated by COFECE's investigative authority when there are indications that their market is not working properly. The legal standard is lack of effective competition conditions. This process includes a trial-like procedure in which provides to economic agents the opportunity to challenge the investigating authorities' preliminary views and propose remedies. COFECE has performed a lot of these kind of investigations, one in e-commerce, and that it's now ongoing, freight transportation services, railroad services, etc. There is another type of market study that is formal market studies that are ordered by the Board of Commissioners. These studies should be aligned with the strategic plan that the Commission establishes every 4 years, and there are criteria for doing that, and some of them is choosing sectors that will aid more vulnerable parties in population in Mexico. For such studies, COFECE has the power to formally issue requests for information to economic agents, and typically results in recommendations but not remedies. And now, for example, there is one particular ongoing market study that is very relevant, that it's on digital financial services. So, I mean, this is where COFECE will want to understand how the market plays. Other advocacy documents performed by COFECE address various issues with stakeholders invited to share their views, but there are more advocacy documents. So what is relevant is that COFECE has used various advocacy tools, and including in-depth market studies. So since we are referring here to market analysis to understand emerging markets, I will mainly refer to the second category, that is formal market studies, as I believe this is the most suitable tool for this purpose, without prejudice to the use of other tools, because we know that they are complementary and they are not substitute, and of course they are not substitute to actual enforcement. No? In this case, in the case of emerging markets with digital transformation, COFECE established the digital markets units, and this unit has craft and plan future market studies, and now it's actively participating in this digital financial services study. So I know that global competition authorities are focusing in digital platforms. Of course, there are several important topics that come to my mind, that it's, of course, cloud services, AI. There are a lot, but we are conscious that the Competition Commission has limited resources. So they have to be very, they have to think really in which they are going to put their resources. And of course, we will like a very good and in-depth study, and not a lot of studies with not very profound conclusions. So what is important is that successful market studies enhance our understanding of sectors, and for businesses are relevant to gain legal certainty, and of course for improved compliance. So we have to choose that markets that really fill a gap of knowledge, and that's something that is sometimes not easy to focus. Of course, while there is not formal public consultation on topics for market studies in Mexico, the private sector indirectly influence these topics to COFECE, because COFECE is also engaging, interacts with various stakeholders, and of course it's monitoring academic and industrial discussions on relevant issues, so they have the sense of what is important for the businesses.
Yeah, thank you, Lucia. I think most of us has budget constraints, and your point of prioritizing the conduct of studies is very important. So moving to our second round, let's discuss the methodology and practical approaches in conducting market studies in emerging markets. So Saverio, with many years of operation of AGMC since 1990, what do you think are practical approaches of your agency in conducting sector inquiries or market studies, especially on data collection and analysis, and what were the challenges encountered, and do you think you need to hire external experts or consultants to help you in your sector inquiries?
Thank you, Ken. So in conducting our sector inquiries, the authority makes use of a number of tools in order to collect and to process all the information and data, to properly understand the functioning of the competitive dynamics. The most important way to collect information is a very simple one, the request for information. Request for information sent to the companies active in the relevant sector, sometimes to their suppliers, to their customers, to trade associations. Before these requests for information were if a company did not reply to the request for information, the authority could not do anything. Following a very recent legal reform, instead, failure to provide the requested information or the provision of misleading, inaccurate, or false information may result in issuance of fines. So now, the powers of the authority has been reinforced under this respect.
Do you have a subpoena power if they want?
We don't have a subpoena power in itself, but if they do not reply, now we can issue fines. So fines that are not extremely high, but if they never reply, you keep issuing fine at the end of the day. Before, in any event, even before having this power, companies try to cooperate as much as possible with the authority. They are happy to provide them. They were happy to provide information. We couldn't just check their correctness. Sometimes we have meetings with a representative of the companies, which is another way to acquire information. It allows a dialogue, an exchange of views. In 2016, for the first time, when the sector inquiry on vaccines for human use was launched, the authority issued a call for inputs. input, which is another effective way to get the views even from companies that are not the addressees of a request for information. So any interested party can provide its own views, and the authority, of course, tries to select the most important ones, but there may be some other companies or interested parties that want to provide their view, and so it is good that they do so, and that's why we will have a more systematic use of calls for input. Just on Monday, the Italian authority published its communication on new communication on sector inquiries, and which explicitly provides that any time we launch a sector inquiry, we need to ask for inputs. So anybody can provide his view. The authority in the past has also carried out inspections in 3 occasions. This was used very rarely because, of course, this is a very invasive tool, and we must make a very cautious use of such a way of acquiring information. You asked about the possibility to involve third parties, technical experts, as you're doing in India, I understand. I have to say that the authority has most of the time conducted all the study in-house. We have an excellent chief economist office, with a very valuable economists working for the authority, and so they can carry out some economic analysis by themselves. And some of the sector inquiries were more related to understanding the legal framework, to better understanding the legal framework, and check if there were some loopholes that needed to be improved in order to better allow market entry or the exercise of a relevant economic activity. However, the third party consultants can be helpful, and the authority did use them in 3 occasions only. Two of them are quite date back a long time ago. By contrast, in our most recent sector inquiry, which concerns the algorithms to set prices of flights for and from the Italian islands, Sicily and Sardinia. We have involved 3 external consultants. We prefer to work mostly with public institutions, such as university or spin-offs of university, because of course the public interest is more in line with that of the authority. Sometimes this is not possible. For instance, for this sector inquiry on the prices of flights, we are also conducting a survey, interviewing people at the airport, and we asked a private company to do that. And so in the future we may rely more on third parties, but third parties are very important when you have to analyze massive amounts of data sometimes, because we do not have probably the technical capabilities to do that. And so in one of the companies that we have hired for this latest inquiry on the algorithm to set prices in flights is exactly to analyze millions and millions of data and come up with a pattern, understanding a common pattern, and hopefully we will make it public in the next few months.
Yeah, thank you. So Chair Ravnit, kindly share to us common challenges that CCI encountered in collecting data relevant to the emerging market in question. And how do you manage to address the lack of technical capacity, since we have mentioned about third-party assistance, to implement the ideal research design? Go ahead, please.
Thank you. In the case of emerging markets, there are a couple of challenges we identify. One is that sometimes the market is so dynamic and changing so rapidly that for you to be able to grasp the entire nuances of the entire sector or the way the companies are operating in that area, that can be one challenge. The second is that as the companies grow bigger, they are very hesitant to share information. So they would like to keep things to themselves. And the third issue is the issue of technical information. Sometimes the information is so technical that you need to be able to decipher as to what are the way they are operating and what are the implications of that. Are there any competition concerns in that or not? So the way the Commission has been addressing this issue is basically that we do have a research and trend analysis wing which does some basic analysis, and that's when the concerns get flagged. That these are the issues or these are the sectors where things are changing very rapidly and we need to understand them in greater depth. But the method which has been used, the mechanism, is basically that we have a very clear differentiation of a market study from an enforcement action. So that's something which gives more comfort to the stakeholders, and they are more forthcoming. The second, of course, as I said, was an engagement with the various stakeholders. So you engage with the other parties who are also in the same marketplace. So that's from where the technical information that is coming to you, you're able to understand it in a greater detail as to what are the implications of it and are there any competition issues which are arising from it. So the third, of course, is when we decide to launch a formal study, then by and large, the internal divisions are only providing the hand-holding support, and the entire market study is we decide on the terms of reference, the RFP is floated, and finally the study is done by a third party. So that brings some level of independence that, we are very open in our conclusions. We have not made any firm decisions. We are not out to get anybody. That is not the purpose of the Commission's market study. We only wish to have greater information. And sometimes it is very helpful, because what happens is that in a couple of studies, there were some recommendations which were made by the Commission which was for self-regulation. But then those become a trigger for the other parties to come to us formally. If they feel that, this was what the Commission had suggested to the players, the e-commerce players or the cab aggregators, and they have not complied with it, then it becomes a case of enforcement. So we don't directly get into enforcement when we do a study. That's basically to be able to get as much information as we can out of the process.
That's quite a systematic approach, which I think we could learn from your accomplishment. So, Song-Sam, in the case of KFTC, what are your operational approaches to effectively conduct market studies on emerging markets?
With regard to the methodology of our emerging market study, I would like to explain our approach by illustrating one that the KFTC has been working on this year. Within this year, a policy paper will be published on markets for new technology like AI that are susceptible to quickly becoming monopolized. As you are well aware, AI technology can bring positive impact to our lives, such as improvement in productivity and generation of services on one hand. But on the other hand, there is considerable concerns about unfairness, lack of transparency, and market monopolization. So we will review the potential issues in general, such as existing challenges for competition, restriction on market entry, and the potential harm to consumer welfare through this paper, which will guide us in exploring policy direction in the AI industry. For a successful market study that will provide the groundwork for an insightful policy paper, we formed a task force of internal and external experts, commissioned a research project, and will co-host the symposium with the OECD. The task force will ensure that opinions of relevant industry and private sector are well represented in the paper, and the global discussion shared through the KFTC OECD joint program will be reflected as well.
Yeah, so forming a task force and hosting a symposium are indeed very practical approaches. So Lucia, what do you think is the role of the private sector in the data collection? What advice do you have for competition authorities to make sure that the analysis and results are useful for businesses?
Yes, of course. Market studies serve as a very useful tool for competition authorities because it provides a platform for extensive input from stakeholders. And businesses particularly recognize the value of these studies in shedding light of the dynamics of the various economic sectors. I think that successful market study requires the active engagement on participation of businesses and should clearly define its scope and objectives from the outset. So it's very important to communicate what's the purpose and what is the scope of the study in order to engage the private sector. This involves identifying and clarifying exclusions from the scope and consulting key stakeholders in an open and transparent manner to dive into key issues and prevent any impression of bias. It is true that for formal market studies, COFECE has power to formally request information for economic agents, and that such agents are bound to respond, but there is no better outcome than procuring authentic engagement of the and interest of the stakeholders. Involving companies in the private sector, of course, is crucial, especially in emerging markets characterized by rapid change. This requires creating a collaborative environment where private parties do not feel scrutinized, but are encouraged to participate with the authority. Efficient and user-friendly submissions mechanisms for evidence further facilitates this participation. Of course, there is, for data collections, there is also the idea or the intention sometimes to gather excessive information from part of the authority, and that's why it's very important to target specific information that will be needed. Demonstrating the benefits of participation, such as obtaining guidance or addressing a specific matter as the market concerns, can motivate stakeholders to go forward to the authority. So ensuring there is no fear of retribution for sharing information is also crucial to foster participation. Of course, while there may be a temptation to ask for many questions and gather extensive data, we will try not to give an excessive burden to businesses in order to really have a good communications, a collaborative engagement. And what is relevant is that ensure that questionnaires are targeted and seek data that is available. It's preliminary market interviews or questionnaires to the stakeholders relevant in order to understand how the information is and what information is really available. So in sum, I think that what I am trying to convey is that active engagement to the private sector and trying to communicate benefits of the study, scope of the study, and trying to limit the information to the really necessary information, it's something that is very relevant to make this a successful tool.
So engaging the private sector, collaborating with the private businesses is very important. So now for our third and last round, let's explore on the application of the results of studies and engagement of stakeholders. So Saverio, kindly tell us about the specific applications of the result of sector inquiries or studies, especially in relation to the new powers recently conferred to the Italian Antitrust Authority.
Yes, Ken. In the past, for the 55 market studies that the Italian authority already concluded, there could be only two kinds of outcome. The first one was that we could exercise our advocacy power in the form of recommendations or opinions addressed to the parliament, the government, local authorities, in order to improve the legislative measures. For instance, we in 2007 we issued a report following a sector inquiry into the banking and insurance sector. And we noted that there were a lot of interlocking directorates. So we asked the Parliament to pass a law in order to prohibit such interlocking directorates within this sector, and they actually did it. So as you mentioned in the beginning, this was an effective use of our advocacy powers. Another outcome that was possible is the initiation of an antitrust investigation. We have a couple of cases that I can mention. After a sector inquiry on the status of liberalization in the gas and electricity market, we started an investigation for abuse of dominant position against the incumbent electricity operator. This was in 2005. In 2009, after an inquiry in the market for professional services, we started an investigation into anti-competitive agreements entered into by the associations of these professionals in order to circumvent the laws that tried to liberalize the sector. Very recently, in October of last year instead, the Parliament gave the authority the power to impose, following a sector inquiry, behavioral and structural remedies in order to solve a competition issue that hinder or distorts the correct functioning of the market. Because of its very recent introduction, we have no example of application of these measures, of course. However, our ongoing sector inquiry into the algorithms for the setting of tariffs for the flights for the Italian islands is based on this this legal basis, and therefore there is the possibility, theoretical possibility, of course, that we may end up with some remedies. What is important is that this new instrument enriches the toolbox available to the authority to address competitive issues. And we can intervene in case of bottlenecks, of other criticalities that cannot be addressed with our traditional antitrust tools. We are thinking mostly about oligopolistic markets with high barriers to entry, or the issue of tacit collusion. Yesterday, I attended the Aid of Agencies discussion on AI, and there was also, it was mentioned by Martin Snoep, the head of the Dutch authority, the algorithm collusion. Possibly these tools can intervene in this kind of kind of situation. In any event, of course, since there are authorities that have already this power to impose structural and behavioral remedies since a long time, we can look at the experience of these authorities. I'm thinking about the UK CMA, which have had this power since 2002. But this is an ongoing process. We know that also the Greek authority has had them for 10 years. The German authority since 1.5 years, more or less. I know about the Icelandic, and yesterday and today I learned about the Mexican authority that has the possibility to impose structural and behavioral remedies. So it is very important to discuss among authorities. The ICN is a perfect forum for this kind of discussion, just to understand what are the pros and cons of these very powerful tools, and to try to address these competitive issues in the best possible way.
Yeah, thank you. Now, Chair Rabnit, kindly share CCI experiences in terms of disseminating the result of studies, your application on competition law enforcement, or in terms of influencing policy reforms in India. Okay.
Yeah. So the market studies, once they are finalized, they are published in various ways. We try and disseminate it as widely as possible. We have these, they're put on the website, there are also press releases are given, and then there are workshops held where the information about the findings of the market study are brought out. The basic intention is threefold. That's the way we look at market study as an instrument currently. One is for the purpose of advocacy, that to spread awareness about the way a particular sector is working, and also whether there are any issues currently or what could be potential competition issues later on. So that is one aspect. The second is for the purpose of advising the players in a particular market. So we use it for self-regulation, like in the case of the e-commerce market. There were these concerns that there is a bargaining power imbalance, there is information asymmetry in the marketplace, and that needs to be corrected. So that recommendation was given out to all the players in the e-commerce players in the market. Similarly, when it came to the cab aggregator study, so there was the overall finding was that the people who are using these cabs, they are not against surge pricing, but they feel that the way the rider perception is that the price is not transparently determined. So there has to be greater transparency, and they need to have more information as to how those prices are going to be determined. So that was another recommendation which was made to the cab aggregators, the major players in that industry. The third instance where we've used the market study was in the case of a pharmaceutical sector, where we were looking at generic drugs. And the thing which was coming out is that even though the drugs are generic, the higher priced brands are being preferred by the consumers. And there is a perception that there is a quality variation. So that became an instance for us to recommend to the government, saying that can we have greater transparency, can we have some more clarity on the quality standards and the way they are being enforced, and that the fact that they are applicable to everybody. There was another recommendation which was made in the same matter, saying that can we have a national drug database which is digitally available, which is available online, so that more people are able to have access to it. And this impression that the quality is superior in case you are paying higher price for it, that can be suitably addressed. So the way so far the format has been is the market study is being used for these purposes.
Thank you. In your market study, does it reveal that doctors in your pharma study, that doctors has also an influence to the choice of drugs by consumers?
Yes, I think so. Yes,
Yes.
it is there that once a person trusts a doctor, then they are willing to pay a higher price for it. But that's not something which we can really, because that's more like intellectual property. If a doctor commands that kind of credibility in the market, I don't know whether it will be a competition concern.
Thank you. So, Song Sam, does the KFTC utilize the result of market studies for advocacy activities targeting, for example, government agencies?
The KFTC has been using market researching findings for advocacy activities, such as reducing government regulation that limit competition. I would like to give you an actual example that was a market study led to a relaxation of government regulation that limit competition. In 2022, the KFTC carried out the IoT market study. It revealed that competition in the IoT market is quite strong, but there was a need for deregulation. Specifically to further promote competition over innovation, we need to ease an existing regulation that restricted the telecommunication companies from engaging in other business than telecommunication services. Namely, we viewed that the regulation would act as an entry barrier for telecommunication companies to get into other businesses. To provide you more information, here is how the regulation has changed. In South Korea, an enterprise had to obtain approval from the government to provide telecommunication service. And at the same time, the enterprise needed to get through a similar regulatory process again in order to manufacture IoT devices on its own in accordance with the law. Following our conclusion, we had discussion with a competent ministry, the Ministry of Science and ICT, and it resulted in a relaxation of the regulation. This year as well, the KFTC is ready to examine the climate tech market, which will play a crucial role in the sustainability efforts. We will identify the regulation and the restriction that could hinder innovation and competition in the area. And as always, we will come up with improvement alternatives and offer recommendation to and communicate with the competent authorities.
Yeah, thank you. That's indeed a very laudable initiative to influence reforms or policies in the regulators, of the regulators. Now, so Lucia, how can market study findings best reach or benefit businesses that the private sector often get consulted on the results of market studies prior to, for example, wider publication?
Yeah, well, I cannot stress the fact that to maximize the reach of and benefits of market study findings to businesses, it is crucial that businesses are engaged throughout all the process. From planning, performing the study, to seeking feedback on its conclusions. This is not only to familiarize businesses with the study's content, but also encourage participation and at the end promotes adherence to the findings, to the conclusions. Globally, many authorities adopt the practice to soliciting feedback from private actors before the wider publication of market study findings. I think that these findings are crucial and because allows businesses to interpret the authorities' concerns and to make them more precise in their final version of the study. And of course, this promotes adherence. In Mexico, as stated, for market investigations, there is a stage where affected economic agents could challenge preliminary findings. It's like a trial procedure. But in market studies, this is not mandatory. Traditional, what COFESA do is to engage with the private sector in different stages of the study and interviews. And recently, for example, in the last before publicizing the last meat market study on meat, they called a panel of experts to comment on the study prior wider publicity. But of course, I think that making an open consultation of the results of the study is something that is valuable, and I think it's a very good practice, and that can encourage participation, and of course having more solid and profound conclusions. COFES is very good publicizing market studies. There is forums in the web page, press conference. I mean, there is a wide publicity, but it will be nice to have a previous consultation of the results.
We still have time, so maybe I'll ask Chair Robney to give some further advice to our audience, especially our young competition agencies, in terms of identifying or evaluating or prioritizing the conduct of studies.
Thank you. The way we look at market studies is a way to build more capacity internally. So it's an exercise where we have some information, and we need to look at it in greater depth. So the way the Commission has been working is that the Competition Commission is sector agnostic, but we are not people who know everything. So there are numerous markets which are working, and there's very rapid change which is happening, especially with the advent of technology, that we would find that things are changing very quickly, and the Commission needs to be up to date on that, to be very agile, and to be able to adapt itself and enhance its toolkit. So we see it as a very, very important, very integral part of the toolkit of the Commission for its effectiveness. And there is also a thing that, because the Competition Commission in the case of India is an authority which is also having the quasi-judicial powers, and they are the ones who decide the penalty. So we would also like to maintain that stance where we are independent. So we are not looking at things with any kind of a color or any kind of a, already set mind. We're looking at a sector with a very open mind, and we are willing to even retreat once we find that there is no concern immediately, but there could be some potential concerns. So we leave it very open-ended. In fact, some of the cases also, when we do enforcement work, there are these very small chemist and druggist associations all across the country, which are very district specific, which is below a province also, prefecture or level kind of entities, where sometimes these people come to us, and they have been held in contravention, and they do not even understand English. They are not able to even have lawyers with them. They're not able to recruit lawyers. So we then convert that into an advocacy. Okay, so you can talk in your local language, and we will try to explain to you, because sometimes they come to us and say, what exactly is the Competition Act? I have done nothing wrong. I'm doing my business, and this is the way my grandfathers and my great-grandfathers have done business. So this is sometimes then the role of the Commission turns into that of doing some advocacy with them, explaining to them and telling them that now you're going to go back and hold so many workshops, and you are going to be spreading awareness among all your members of your association. So the way the Commission looks at enforcement is important, but equally important is advocacy. So we need to be very clear about it, that all the time the Commission, there might be very small players, and they may not understand the entire nuances of the Act. So sometimes even in our enforcement proceedings, we convert them, and we do not impose any penalties, and we say, okay, fine, as long as you go back and do this We'll just give you these requirements which you need to fulfill, and once you are done, that's okay. So similarly, the market study also we see more as an advocacy, more towards capacity building, both internal capacity building as well as for other players to be able to understand how things are working. And that is the way we are now approaching this study on artificial intelligence as well. In fact, this artificial intelligence study has been very interesting even before we've started. A lot of work has happened before that, because there are so many good things about artificial intelligence which are coming out in the press. The importance of artificial intelligence, especially for the healthcare sector. There are so many good things which are going to come out with this data, the analysis of data, the outcomes, the diagnosis, the treatments, and things are going to improve so much. So when we decided that we needed to do a study on artificial intelligence, then my team, they started interacting with the top institutions in the country. So we had interactions with the top lawyers who are working in the artificial intelligence space. We also interacted with the Indian Institute of Technology in New Delhi, which is the Institute of Excellence. And that's how we framed our scope of our work. So we spent a lot of time on where exactly do we wish to go, because artificial intelligence is such a big area that you can very easily get lost. So we kept on bringing the focus back in our terms of reference, in our scope of work, towards competition, that this is where we are concerned about. It's very positive, artificial intelligence is very good, there'll be lots of benefits, but we have only some areas which we need to be looking at, from how it facilitates anti-competitive conduct. So a lot of time, even though we give it to the third parties, outside parties are doing the implementation for us, but our internal teams are very, very closely and very actively engaged in this entire process.
How do you manage controversial findings, if any, especially with your stakeholders or, you know, government counterpart? Yes, okay. Please. Okay. Just a quick answer.
Yeah, of course. No, so whenever there is a contravention, there is always a possibility of starting a suo moto investigation, which is the Commission has the powers to do that, and it can always initiate a suo moto investigation, especially when we look at some areas where there are cartels, because that's the most egregious conduct, and that sometimes some of the parties, the leniency applicants may not be willing to come out. So that's where the market study can be used as an instrument to start an enforcement procedure. So it's not as though it is completely ruled out, but in a normal course, we would not like to use this as another way of enforcement. Except for advocacy. So there are instances like we are looking at one market study in the cement sector. So that is one area we've looked at. Then there was the post-COVID period. We had this market study which is being undertaken currently, which is on diagnostic medical equipment. So how that market worked, especially in times of COVID. So what can be done better in future? Of course, not wishing that we have another pandemic, but what are the learnings from it, and can we do better next time? So that's.
Lucia, do you have any final remarks?
Well, yes. Of course, what I want to stress is that, of course, I think that businesses appreciate the insights that comes from these market studies. That is, of course, is difficult when we are talking about emerging markets, it's difficult to predict the future. So competition authorities should know the limitations of that. And that's why these studies should be made, review with the time. For example, in the case of COFECE, they made a study on financial services. Then they had a new one in fintech, and now they are doing another one in the financial digital services. So these this knowledge of the sector improve with the time and change with the time, and that's something that we have to think about. And of course, it's very relevant that if we are going to use a market study to create knowledge and to foster compliance, I think that's very good. But of course, if we are going to take remedial actions, then of course we have to balance the due process and the chances to contravene the findings.
Yeah, thank you. Our time is up. And from the insights given by our speakers, some takeaways on conducting market studies in emerging markets confirms that market studies could provide a good understanding of the issues in emerging markets, especially digital markets. And I note that there are many practical approaches in conducting studies which may help clarify competition issues we are dealing with. And it was clear in the discussion that the market studies would indeed help us develop better regulation, smart regulations, and processes for effective enforcement of competition law in emerging markets. And studies could also help us manage our stakeholders and sector regulators better through more informed advocacy initiatives. So with that said, join me in thanking our speakers for sharing their insights and experiences. Thank you.
Thank you to all speakers again, and thank you to the moderator for this panel. And we'll have one more session for today. Is that already? Thank you very much. Well, we have one more session for today, the ceremony to announce the ICN World Bank Advocacy Contest winners. Before we start with the actual ceremony, I would like to invite to the stage Andreas Mund, Chair of the ICN Steering Group and President of the Bundeskartellamt, and also invite to join the stage Maria Tavares from Brazil, NGA and member of the evaluation panel of the contest, and Roberto Rustichelli, Chairman of the Italian Competition Authority, Italy. Mr. Andreas, the floor is yours.
Well, thank you very much. I'm very happy if you stay for another 15 minutes because I think the award is really an important issue, and I'm very happy if as many as possible could stay. Well, the ICN was founded in 2021. And advocacy from the start was the second pillar we started with, because when the ICN got started, there were only two working groups, and they were on mergers and on advocacy. And now, 23 years later, our commitment has not waned, and I think in times of economic crisis, rising industrial policies, complexities of subsidies, trade tariffs, our commitment to advocacy is more important than ever, and we have learned how important it is also from the panel that has been here today, and it is a responsibility that we all have to convince policymakers to embed competition principles in their public policies always. Now this year it is more vital than ever, and I'm very happy to present to you the winners of this year's competition advocacy contest. This year is a bit special because we celebrate the 10th anniversary of this contest. And this is why this contest is an effort to cooperate as ICN with the World Bank on behalf of the ICN and, of course, our Italian competition agency in Rome. And I'm very honored that I have inaugurated this initiative every year since the first contest in 2024. So that is already a tradition in itself. As you say, when you come from Bonn in the Rhineland, if you have done something twice, it is a tradition. So 10 years is a very rich tradition, I can tell you. So today, we are not only here to forward the awards to the winners, we are also here to forward an award to those who have been accompanying and initiating this contest over the last 10 years. The World Bank, it's very sad, but it is as it is, cannot be with us today, but I'm very, very happy that we have here with us Roberto Rusticelli, the head of agency of the Italian competition agency, and Mariana Tavares, whom I know also for, I don't know, 20 years, Mariana at least, and she has been with this contest also for very long. Have you been there from the start, Mariana? From the start, since 10 years. And I can tell you this is hard work to do the right pick for whom is the award and who'll get one maybe next year. I'm not so happy that we have won so few awards, Mariana, I must say that now, so I hope for a better future. But I'm very happy and proud that you have done this, because I know this is a lot of work and you must take a close look at everything. And of course, Roberto, your agency, you yourself, you have been engaged since 10 years. And I'm very happy that we are here today. So I think we should give a huge applause to Mariana, to Roberto, and to the World Bank that is not with us today. Not to forget, Eleanor Fox is not with us today, but she has always been very, very engaged. I admire Eleanor a lot, and this is only a tiny piece of what she does in the realm of competition and also for the ICN. So, for now, you who spend awards, you will receive an award today. Very well. It's up to me now to congratulate already now to all the winners. And having said that, I hand over to you, Mariana, and to you, Roberto, in order to grant the awards. And I go back and with a little hope. We will see.
Oh, I'm sorry.
Good evening to all. On behalf of the Advocacy Working Group co-chairs, I'm very honored to welcome you to this award ceremony. It has been a real privilege for Italian Competition Authority to work with the World Bank Group over the last 10 years and contribute to this successful initiative. The advocacy contest is a great example of cooperation between two important international organizations. From the very beginning, the Italian Competition Authority has embraced with enthusiasm this brilliant initiative as an innovative tool to collect and promote exemplary advocacy efforts all over the world. Indeed, thanks to its attractive formula, the contest is able to reach out and give visibility to many younger competition authorities. which might not always have the opportunity to participate in the activities of ICN Advocacy Working Group. Furthermore, the contest serves as a tool for exchange of experiences within the working group, and its stories are of inspiration for new projects. One of the reasons for the advocacy context's success is certainly the careful selection of topics which take account of the authorities' concerns and of the economic development. This year's context focuses on advocacy challenges related to the new era for industrial policy and advent of new technologies like artificial intelligence, which outline the importance of international cooperation and strong, resilient markets. On behalf of the Advocacy Working Group co-chairs, I would like to congratulate all the winners and honorable mentions of the year's contest. A warm thanks goes to all the contest participants, whose stories and enthusiasm contribute to the success of this initiative. Now, I'm happy to give the floor to Mariana Tavares.
So, let's start with the ceremony. For the first theme, fostering job opportunities and firm growth through competition advocacy, the winner is El Salvador. And the honorable mentions go to Portugal and the United States. The competition superintendents of El Salvador implemented a multi-year advocacy strategy aiming at promoting a pro-competition culture to address obstacles faced by micro and small enterprises, in particular with respect to access to credit and public procurement. Please welcome to the podium, on behalf of the superintendents, Mr. Luis Lopez Alvarez, Ambassador of El Salvador to Brazil. Congratulations. The Autoridade da Concorrência, ADC, adopted Best Practices Guide to prevent anti-competitive agreements in labor markets following a public consultation of more than 30 stakeholders. This initiative has led to further investigations, leniency requests and complaints, resulting in sanctioning decisions and fines. Please welcome to the podium Mr. Nuno Cunha Rodrigues, President of the Portuguese Competition Authority. Congratulations. The U.S. Federal Trade Commission banned non-compete clauses nationwide to promote competition and protect workers' freedom to change jobs whilst fostering innovation and boosting new business formation. The FTC received overwhelming support for the proposed ban on non-compete clause, which affect around 30 million workers. Please welcome to the podium Paul O'Brien, Counsel for International Affairs from the US FTC. Congratulations. So let's continue with the second theme, competition advocacy to leverage new technologies while limiting the risks for markets. The winner is Paraguay, and the honorable mention goes to Spain and Portugal. The Paraguay Competition Commission collaborated with the Football League to remove restrictions on the tender process for broadcasting National League football games, while in the payment and transport sectors, the Commission's advocacy efforts have maintained innovation coming from digitalization. Please welcome to the podium Eduardo González Martínez, President of the Paraguay Competition Commission. Congratulations. By establishing a robust public procurement database and developing specialized IT tools and expertise to detect red flags in the design of tenders, the Spanish National Markets and Competition Commission has positioned itself as a vital resource for procurement agencies and improving tender processes nationwide. Please welcome to the podium Maria Luisa Tierno, Director General for Competition, and Renata Sanchez-Loriano, Advisor at the Market Studies and Reports Unit of the Spain CNMC. Congratulations. After comprehensive research and field studies, the Portuguese Competition Authority published a paper on generative AI, its economic impact, and the competitive landscape of its nascent value chain. This initiative demonstrates the agency's readiness to address AI-related challenges and remain vigilant in the digital sector. Please congratulate with me again, Nuno Cunha Rodrigues, President of the Portuguese Competition Authority.
And now for Team 3, embedding competition in industrial policies through advocacy, the winner are the Turkish and the Spanish Competition Authority. The honorable mention goes to the New Zealand Commerce Commission. Following the devastating earthquake in February 2023, the Turkish Competition Authority implemented measures to support the economy. They initiated a study focusing on key sectors like construction and healthcare and collaborated with the local stakeholders to prevent opportunistic behaviors. Please welcome to the podium Ezra Kukukikis and Seabat Hilmath, competition experts at the Turkish Competition Authority. Congratulations. In a study carried out in 2023, the Spanish Competition Authority found that the state broadband deployment program had a positive impact on internet connectivity and market competition in smaller, less attractive regions for private investment. Please welcome to the podium Maria Luisa Tierno, Director General for Competition, and Renata Sanchez-Loriano, Advisor at the Market Studies and Reports Unit. Congratulations. The New Zealand Commerce Commission, in partnership with the government, developed tools to help public officials apply competition principles. These include a quick guide and detailed guidance, which have not reached over 400 public officials and are integral to the government's regulatory impact assessment. Please welcome to the podium Nick Wilkins, Intelligence and Investigatory Process Manager at the New Zealand Competition Commission. Congratulations. Finally, for the last category, raising awareness on competition by communicating on impact and results, the winner are the Hong Kong Competition Commission and the Mexican COFECE. The honorable mentions go to the Competition Authority of Egypt and Poland's Office of Competition and Consumer Protection. In 2022, following the convention of 19 companies for cartel involvement in home decoration services, the Hong Kong Competition Commission launched a TV docudrama. This series, which was very successful both on television and online, led to a 30% increase in compliance to the Commission. Please welcome to the podium Gary Hsu, Executive Director Policy and Advocacy at the Hong Kong Competition Commission. Congratulations. In 2023, the Mexican COFECE published a commemorative book to anniversary of the first competition law. The book reflects on past lessons, current assessment, and future challenges, stressing the role of an independent public institution in promoting a competitive economy. Please welcome to the podium Andrea Marvan-Saltiel, Chair of COFECE. Congratulations. To address the gap in competition awareness, the Egyptian Competition Authority launched a program for academic institutions of the North African region. The initiative includes a learning platform for students and a network of competition advocates to enhance regional collaboration and knowledge sharing. Congratulations to the Egyptian Competition Authority. Finally, the Police Office of Competition and Consumer Protection introduced the Summer Camp project to develop skills in competition law among university students. This initiative not only promotes careers within the agency, but also positions the institution as a collaborative and future-oriented workplace. Please welcome to the podium Tomasz Kroźny, President of the Office of Competition and Consumer Protection of Poland. Congratulations, Tomasz. The ceremony is over. Thank you very much. Thank you very much for your attention. Now, I would like to make a family photo.
Thank you very much. Ladies and gentlemen, we had a very productive day again today, and I would like to stress that tomorrow morning we'll still start with the breakout sessions round 4, followed by the Agency Effectiveness Working Group plenary titled Monitoring and Evaluating the Effectiveness of Agency Actions, and the closing session. I have an important information, please. So in this room, we will meet again tomorrow for the Agency Effectiveness Working Group plenary session right after the morning coffee break. Let me remind you to get the vouchers for the bus to Projeto Tamar at the registration desk and to buy your tickets in advance. You are all invited to the ICN conference dinner at the arena at 7:30 p.m. Have a great time at dinner. Thank you very much and see you tomorrow.